Adjournment request, if any, from item number 1 to 6.
1 to 5. 5, 8.
May please, Lord. Well, I basically mentioned item number 5 and 6, madam.
Yeah.
That will be taken up day after tomorrow, madam.
Yeah, after tomorrow.
Day after tomorrow. I have taken the concept of plans.
Why? Day after tomorrow.
There's some difficulty on our part, madam. On the part of the statement.
The Sekya was supposed to.
Yes, madam. That is why, madam. Praying for item number day after tomorrow, madam.
Day after tomorrow.
Oblige, Lord.
May I please, madam, with the consent of the applicant, I beg to mention item number 9, my lord. Madam, matter be taken out of first week of December.
Adjourn.
I'm obliged.
May it, Lord. Is the lordship. That I beg to mention item number 8, my lord. In this case, my lord, the respondent number 1 expired, my lord. Expired. So I may be allowed 1 month's time, my lord, because my trustee is 84 years old, my lord. He is lying in Calcutta, bedridden. So I pray for one month's time. Let me consider the plan. It's 4 weeks time to move appropriate application to bring on record the legal representatives of respondent number 1. Expired on when he was expired?
24, 2022.
Expired on 24.
20th of April 2020.
20th of April 2022.
My lord.
Time period for his granted list of 4 weeks.
Obliged, my lord.
Yes.
May please, your lordship, with regard to item number 14, my lord. Some personal difficulties, my lord. The matter may come in the next week, my lord. Item number 14.
Adjourn.
Highly obliged, lordship.
Please, your lordship, beg to mention item number 17, your lordship. Matter may be adjourned for a week, your lordship.
Adjourn.
Lordship, can it kindly be taken up on 11th, my lord? We have urgency in this matter.
11th is not the hearing day, it's a hearing matter. What? $14.
Much obliged.
May I please remind? Case for listing of 2 interlocutory applications, my lord. In the lottery matter, similar orders were passed, my lord. We are seeking similar release, my lord. Tomorrow, my lord.
Festival is already over.
No, it's still there, my lord. Similar. Tomorrow, my lord.
Next.
Deeply obliged, my lord.
Any other request? Daily list for admission, item 1.
Anybody, my lord, on behalf of the state?
I appear for respondent to forest.
Respondent?
Number 2.
Forest department is not as much role. What about the other respondents who are constructing this road?
Yes.
Which is that department?
Basically PWD, my lord, Public Works Department.
Yes. Yes. Yes, do you have any instructions about that?
Lordship, here, the instruction that we received, Lordship, it's a handmade map, Lordship. Here the red dots, Lordship, the trees which will be cut up. Lordship, may take it after some, I have just been informed, AG will be appearing, Lordship, just after a few minutes.
So maybe you please let us know what your position. Whether there is any move on behalf of the state government or the agency to protect those trees.
In fact, my lord, according to our instruction, they have already identified 20 number of trees.
That they have marked that.
Yes.
Lordship,
28.
I
I have to make my submission. This petition is nothing but a publicity seeking litigation. That is number one.
Fine.
Number two, when there was some sort of protest on 29th, immediately on behalf of the government, the chief minister issued a statement. I have the copies also. That we are not going to do anything. We are respecting the sentiments of the people. And let me bless this. It is in public domain. The at 9:30 on 30th October. The chief minister made this statement. I want to assure you that the government is deeply committed to preserving our city's heritage and environment while advancing infrastructure. In constructing the flyovers from Dighalipukhuri to Nunmati, we are sincerely working to protect the old trees in the area. I urge all stakeholders to allow the Public Works Department a few days to explore an alternative proposal and assess its feasibility. So this is the first statement. Then another statement from the Chief Minister's office. It was issued same day at 7 p.m. As per instruction of Honorable Chief Minister so-and-so, Dr. Ravi Kota chaired a meeting with senior officials of Public Works Department roads to discuss possible alternatives for the upcoming GNB flyover in order to avoid West and East Dighalipukhuri Road. Instructions has been issued to prepare a draft traffic flow to ensure that the flyover ends at GNB Road itself or any other alternative route to avoid cutting of heritage trees in Dighalipukhuri area. The PWD team will submit their report within a week with proposed modalities. So nothing survives here at this stage. I would like to make a statement also.
It's on whatever the social media. Give it in writing.
Let the matter come in a week's time. On that day, I'll make the final statement also.
my lord, just now.
No
learned
notice
advo-
may be issued.
My lord, just now, learned advocate general has read out the second one. First one, CM says, this writ petition was filed on 28th. Fine. And the same day, maybe in the later part, that statement was made. Now, actually, I've just heard my learned friend reading that if the flyover ends at GNB Road, my lord, perhaps that would be in everybody's interest. My lord, let me make one submission, my lord. Apparently, my lord, before proceeding to go ahead with this construction of this flyover, no expert opinion was taken. my lord.
I would like to address one more.
I think my learned friend will get his time to reply. He's too excited, my lord. Now, my lord, issue is, we are citizens of this country, my lord. We also have a say in the matter. It's a democracy. My lord, we all know under the constitutional scheme, cabinet enjoys a different position. And whatever decision cabinet is taken, they having the trust of the people, they can do. But the issue is, my lord, in a democracy, the government of the day should also listen to the people.
No,
My lord, what I'm saying is, my lord, now this GNB border, the GNB road flyover, my lord, what sense does it make to extend it beyond GNB road point, my lord? I may not be an expert, but I've seen it in and out. My lord, if two arms is to go towards the, my lord, both sides of the Dighalipukhuri, where is the space for the road? So are these, and who is the agency who has been entrusted with this work? One agency called Gautam Construction, my lord. What is their experience? There are no other, my lord, it's a very heavy work, my lord. 800 crore rupees is involved.
We are, what agency?
My lord, these contracts
what
are not
agency
given
is
for
doing-
public purpose.
So, Mr. Choudhary, which agency the government is entrusting which agency to do what work without going into this? Yes, you're concerned about the trees, old trees.
Not
We are
only
aware
trees,
of
my lord, regarding the alignment also. My lord, we are the Guwahatians. We have right to say that this is good, that is bad. No, if authority cannot arbitrarily decide, my lord, authority must listen to our voice. Merely because somebody is sitting in like the glass house in Dispur, does it mean he will not listen to anybody?
So far as regarding alignment, etc. is concerned, sir, he may not have that much of expertise and that it's better to leave it to the authorities concerned until and unless the alignment is so bizarre or
Exactly.
something else, we'll consider that.
Yes.
But
My only submission is,
At
my lord,
present, we are concerned with that. If the state government is aware of the situation and they are contemplating to protect those trees for which essentially the people are agitating, well, ask them to find.
my lord, my humble submission is, my lord, of course, is not a part of the pleadings in this case. We have issues regarding the alignment also, my lord. As just now, my learned friend has said that they're attempting to end it at GNB Road, then we have nothing to say, my lord. But beyond that, it makes no
They are
sense.
contemplating.
Yes.
That's why
So, my
only we
lord,
ask them to file the.
File an affidavit, yes.
This PM petition was filed by the petitioners essentially. Raising a grievance. Essentially, essentially raising a grievance that the state agencies have decided to construct two arms, that is Tabula Road, 390 meter, and West Digali Pukri Road, 250 meters, connecting with the under construction elevated corridor slash road on GNB Road in bracket from RBI office to Ambabadi to FCI Godown in Noon Mati. Stop. It is contended that on account of construction of the above referenced arms, the old trees aged about 100 years or more are required to be cut, which may be detrimental to the environment and ecosystem as a whole. It is contended that those 100 years old trees are heritage and should be protected at any cost. Full stop. Looking to the nature of the issue raised in this PIL petition, we deem it appropriate to issue notice to the respondents to file their response. Just a minute, don't write this. Learned additional advocate general, advocate general appearing on behalf of the state of Assam has informed this court that the matter is under active consideration of the state government and Honorable the Chief Minister as well as the CMO office has already assured the public that the government is discussing possible alternatives for the upcoming GNB flyover in order to avoid west and east Digalpuri road and to avoid cutting of Harris's tree in the area. Full stop. Learned Advocate General has placed on record two posts on social media, one by Honorable the Chief Minister and another by Chief Minister's office. Full stop. With that as it may, looking to the issue raised in this PIL petition, which is of great importance, we deem it appropriate to issue notice to the respondents. Issue notice, Learned Advocate General put in appearance on behalf of the respondent number 124.
Yes. Let the issue, let it be issued only to number one only, because the chief secretary is there. So we'll file an affidavit on behalf of the CS.
1 and 3.
Even without notice for we'll file an affidavit. And because the thing is that already the issue has died down. But these are publicity, and if a notice is issued, a different kind of things come out in the media. Let me be very honest. And number one. Number two, Lordship.
Why are you worrying about
That
media?
number one, number two,
Okay.
the trees were only marked. There are a lot of activities has to be considered thereafter.
Yeah.
When the trees were identified, it was not for cutting. Let me clarify this honorable.
Clarify all this in the affidavit.
It was whether these trees can be transplanted or not. Maybe it can be removed to 10 meters away or not. For that one party from
Whatever.
Haryana also, but we are not going to that. We have completely abandoned that scheme now.
Fine.
But it was not for cutting. The wrong conception has been given.
You clarify it, we'll consider it.
In that matter, let the chief secretary file an affidavit, Lordship.
We'll do one thing, sir. We'll, for the time being, we are issuing notices to the respondent number 124 only. You file
Only
a
once.
collective affidavit
We'll file an.
looking to so-
In fact, Lordship, we have
Issue
three
to the
options now.
respondent Number 124.
We have to finalize one option.
For the time being. The, Mr. Learned Advocate General accept notice on behalf of the respondent number 124. He pays for and granted. How much time?
Let it come on 13th, Lordship.
He pays and granted some time to file.
We'll file it by 11th. And
Counter to the petition. List on 13th.
Deep seven.
Counter to the petition on behalf of the respondent number 124.
Item number 2,
Item number 2, Lordship, we have been newly engaged in this matter, Lordship. We have circulated an adjournment request, Lordship. May I plead the matter may come after 2 weeks, Lordship.
Who is appearing for the other side?
Lordship,
You are appearing. Adjourn.
item 3,
Yeah, please, my lord. My lord, the order passed by the Central Administrative Tribunal, my lord, interfering with the transfer order of the respondent, my lord, is under challenge, my lord. My lord, before I start, my lord, I would just like to place on record that the concerned employee has joined, my lord, to the person to the transfer order.
Then why we haven't assigned him any posting?
No, my lord, he has joined the place of posting where he was ordered to be transferred.
Fine.
My lord, on that was, my lord, for a person to the
What about salary?
my lord.
What about the salary?
Salary has been paid, my lord. That has been paid.
Yes, Mr. Majumdar. Salary has been
We are on the merit of the case.
And my lord, during
paid. Now,
the,
once you have joined, what remains?
And I have joined because your lordship has said unless you join, we will not hear the case on merit. So today, your lordship will kindly hearing on merit. Here is a case, it's a clear case of malafide. I will show, my lord. Documents will show two things, my lord. I am challenging the order before the tribunal on two grounds. One, it's malafide, absolutely malafide. I'll show, my lord. And second is, my lord, it is arbitrary because their transfer policy which they framed pursuant to a direction of the Honorable Supreme Court, that they are not following. They are following in all other cases. In my case, they didn't follow. Reason is very simple, my lord. I raised voice against purchase of a particular machine, they got good laundry or something. The contractor did not, my lord, supply all the materials, but still he wanted to commission. Officers were all hand in glove with him. I resisted. That was the reason for transferring me out, my lord. And I'll show, my lord, because of that, I'm not saying malice in fact, my lord, I'm saying malice in law because, my lord, because of that, by virtue of on the strength of a telephonic order, I was transferred. Now, their guidelines say that there has to be a proposal which has to be recommended. And this policy was framed pursuant to a direction issued by the Honorable Supreme Court. I have brought the judgment also. And, my lord, and I'll only hearing, my lord, I will only submit one thing. My lord. Here is a case I find, unlike other cases of transfer challenge to a transfer order, my lord. An honest officer has been treated in this way. Unless he is protected, my lord, it will send a very bad message to the department, my lord. I'll show, my lord, records from their record.
my lord, in fact, the particular employee has represented against his transfer order. And my lord, will see page 100 is the reasons given and his representation was disposed of. My lord will take page 100. If I may read, my lord.
Yes.
In reference to the letter above, it is informed that your request for cancellation of transfer order from NF Railway to SCR wide Railway Board's letter, page 100, my lord. My lord, yes.
Yes.
In reference to the letter above, it is informed that your request for cancellation of transfer order from NF Railway to SCR wide Railway Board's letter number 5923 was put to competent authority for consideration. However, the competent authority has passed the following remarks. I have gone through the representation of Shri Kundan Kumar against the transfer order. Shri Kundan Kumar has worked all alone in NFR since induction in Indian Railways. He has long career ahead and has about 20 years of service. He has completed more than 8 years in NFR for career progression. He requires wide exposure in the other railways also. It is considered prudent to more exposure for career progression. There is nothing against him on record as submitted in the representation. The transfer order is on administrative ground and for betterment of his career growth. So, my lord, while disposing of the representation, my lord, the authorities have made a categorical finding that whatever the allegations of malafide the petitioners is alleging, my lord, in the representation, there is nothing on record. In the service record, my lord, there is no disciplinary proceedings, no action taken against the petitioner.
That is what
And my
this
lord,
case is.
Yes,
to prove the allegations of malafide, my lord, malafideness cannot be proved just by a submission, my lord. the allegation against whom the party, the person has to be made party to the petition, my lord. Well, I have in support of my submission, the judgment. My lord, in the entire petition filed before the tribunal, my lord, there is an allegation of malafide. In fact, specific persons are named, my lord, against whom the allegation of malafide was made. But my lord, those persons were not made party to the proceedings. So, my lord, how can the malafide be proved, my lord? Just making submission that there was a malafide, my lord, that doesn't prove the allegations of malafideness. And my lord, I'm relying on the judgment, my lord, at paragraph 25 and 27. My lord, 2013, 1 SCC 524. If I may read, my lord, paragraph 27. Paragraph 27. That there is yet another aspect which cannot be ignored. As in when allegation of malafides are made, the persons against whom the same are leveled need to be implemented as parties to the proceedings to enable them to answer the charge. In absence of the person concerned, as a party in his or her individual capacity, it will neither be fair nor proper to record a finding that malice in fact had vitiated the action taken by the authority concerned. Here, my lord, in the entire original application filed before the tribunal, there are specific allegations against the person named. And the learned tribunal, my lord, has directly come to the finding that the allegations of malafides is proved without giving any opportunity to the persons concerned. So, my lord, in my humble submission, my lord, that is, my lord, not correct. And secondly, my lord, regarding the violation of the guidelines, my lord, the learned tribunal has, my lord, applied the principles of, my lord, with transfer within the zone, whereas, my lord, the petitioner, the respondent, my lord, he has been transferred inter-zone, my lord, from one zone to the other zone, my lord. So therefore, my lord, there was no violation of the guidelines, nor, my lord, there was any allegations of malafideness, my lord, while passing the order of transfer. Page 166, my lord, is the details of the posting. My lord, since he has joined the NFR. And my lord, another aspect, if I may point out, my lord, the transfer order was issued on 14/9/23. There was no stay of the transfer order, my lord. And my lord, as per the my lord, the judgments of the Supreme Court, my lord, the employee should have joined the place of posting. Now, my lord, he has got the salary for entire, my lord, 1 year without working, my lord. One more.
With the transfer order,
Page 96. Page 96.
96.
96.
Lord, he was paid from NF Railway in 23 itself, my lord. From 59/23, my lord, till May 2024, the employee has not joined the place of posting. However, my lord, pursuant to lordship's order, my lord, he got the salary for the said period, my lord.
Yes.
My lord, I'm relying on the recent judgments, my lord, regarding joining at the place of posting, my lord, that it is a duty of the employee, my lord, to join the place of posting unless there is a stay, my lord. There was,
That matter is over.
Yes.
so my lord, the point, my lord, I'm trying to make already, my lord, he got the benefits, my lord, without even, my lord, working. He was sitting, my lord, from 59/23 to May 24. He got the salary, my lord.
Fine.
This is the recent judgment, my lord, paragraph 5.
Yes.
The focal consideration behind it is that the intent of transfer is to fill up certain vacancies at new place of posting. And when the transfer employees fail to join such posts, the said vacancy would continue and the goal of providing optimal service at full capacity remains defeated. And even worse situation would arise when the authorities, while the challenge to such transfer is underway, would have to employ other individuals to fill up the such vacancies and has to ultimately spend from both the pockets by providing salary to the employee who is actually delivering service as well as to the employee who has remained absent from the service unauthorizedly. It cannot be ignored that such a situation would result in nothing but burning a hole in the pocket of the public exchequer, leading to excessive financial burden on the government institution and would fundamentally jeopardize the public interest. My lord, so far as the allegations of malafide is concerned, my lord, since none of the persons named are made parties, my lord, that allegation of malafide now I cannot be proved at this stage, my lord. It ought to have been proved before the honorable tribunal. Now here, my lord, in this proceeding, it is challenge made by the respondents, my lord.
Yes,
And my lord, lastly, my lord, with regard to the powers, my lord, I would refer to page 189. Lord, since the respondent was a group A, my lord, employee, and it was a case of an interzonal transfer, my lord, the power to issue the transfer order, my lord, lied with the director general or the member of the board. So that power is given, my lord, at page 189.
yes,
My lord, we'll see it, my lord, he is a JAG, junior administrative grade, my lord, procedure for approvals. And my lord, at serial number 4, my lord, will see the column within zone, the power is with the general manager. And my lord, inter/zonal transfer, it is DG or the member concerned. So there is no necessity of placement committee, my lord, in case of a interzonal transfer. It is the DG, Director General, or the member concerned who can issue the order of transfer, and my lord, it was accordingly issued, my lord. That is not.
Made clear. Well, I'll come to this aspect where my learned friend says he gives his own interpretation to this document to say that no proposal is necessary. I'll come to that at a later point of time. Well, I'll just show what has happened in this case. Lordship, may I kindly turn to page 99 first.
apart from that, you have to satisfy us
My lord.
regarding the findings of the tribunal.
Madam.
Internal page 10 of the impugned order.
Internal page 10.
Para-
Page 31.
On page 31
I'm
of the writ appeal.
para 8, my lord.
Yeah.
Lordship, can you give me some time? I'll build my argument in my own manner. Lordship, will give me time. I'll reply to this.
We are simply pointing out to you
My lord.
that you have to answer this also,
Para 8.
Yeah.
Absolutely, my lord. I have answers to all these.
which is statutory in nature. The transfer policy is statutory in nature.
Well, I'll come to that. Lordship, can you give me just 1 minute? I'll reply to this also, my lord. I'll reply to this also. Lordship, will give me some time. And Lordship, may I kindly turn to page 99 first. And at the outset, I'm making clear, my lord, I am not alleging malice in fact because I have not made them party, and I'm not raising that. I'm saying it is malice in law. A power has been exercised for without any lawful excuse. My learned friend is making possibly, my lord, a mistake that I have not made them party, so I cannot allege malafide. And if I allege malice in fact, I have to make them party. If it is a malice in law, lordships are aware. If it's malice in law, I am saying that the order is bad because the power has been used for without any lawful excuse. I'll show that judgment.
Full excuse, what do you mean by transfer lawful excuse?
Without any lawful excuse, if the power has been exercised, then it is malice in law. For that, I am
Very difficult, sir. Lawful excuse, what do you mean by lawful excuse?
my lord, lawful because why I'm saying
You're
that
saying that
the
we
power
under the administrative exigencies for betterment of your career projection
Yeah.
or something, else, what they are saying.
yes.
And what do you mean by this lawful excuse? So in
My lord,
each and every
my lord, this is
transfer,
what- my lord,
the
this-
employer has to show the lawful excuse.
My
for
lord,
that.
this is what the Supreme Court says. If I I know my limitations. I'm challenging a transfer order.
The whole thing is
My lord.
that we are exercising supervisory jurisdiction
Absolutely,
and judicial review of the impugned order.
my lord.
You have to defend that order. sir.
I'm defending it.
The points which have not been touched
My lord.
by the tribunal.
My lordship will give me just 5 minutes time. Your lordship will kindly bear with me. I'm just showing, I'll satisfy your lordship. My lord.
The problem is that we can't, the points which has not been touched by the tribunal.
My lord,
We have also not challenged that order of the tribunal. In fact, the other party has challenged the order of the.
yes, my lord.
We have to see whether this challenge is to be maintained or not on the ground which they are raising.
My lord, I'll come to that. Lordship, may I kindly turn to page 99, my lord.
Yeah.
Page 99 is the,
Just a minute, can very well argue all these things.
Right.
If the tribunal has gone into that.
Right.
And to justify that finding, you can very well argue.
Right.
This, the finding of the tribunal is justified on account of these
absolutely,
facts.
absolutely.
But if the tribunal has not even touched, they have interfered with the transfer order on the ground, that first of all in violation of the
Policy.
transfer policy.
Right.
And second is suffering from malefides because as per the tribunal, it was the transfer order was made to accommodate one Ashok Kumar. These are the 2 points
Right.
which the tribunal has interfered with the transfer order.
And disturbing the academic career of the students, children also.
That's it includes in the transfer policy.
My
The
lord.
only thing.
My lord, I'll address your lordship first on the first point, whether the tribunal was correct in interfering with the transfer order on the ground of transfer.
Yes.
I'm coming to that, man. For that, well, I'm developing this argument. Lordship, may kindly see page 99, man.
99.
My lord. Because unlike other transfer policy, here is slightly different because there is a Supreme Court judgment which says that this has to be the transfer policy. My lord. Page 99, man. This was my representation, my lord. With due respect and humble submission, I would like to state that I was transferred from Mechanical Workshop Dibrugarh to Coach Maintenance Depot, Guwahati in the month of February 2023 and posted as Senior CDO Guwahati. Being Senior CDO, I have continuously monitored and executed the contractual work without compromising the quality of service by taking a number of initiatives that resulted into bringing down the number of passenger complaints. Sir, in addition, with that, I have motivated and encouraged my subordinates to work rigorously during duty hours despite large number of complaints from trade union. Sir, someone tried to create conspiracy with bad intention against me to tarnish my image by propagating false information to social media, news media, as well as to the administration. Sir, in one of the instances, I had denied commission of a boot laundry despite repeated requests by the farm, as the farm has not supplied the basic parts of main machine, which allegedly resulted into circulation of false information and allegation against me via social media. I had immediately informed the same to PCME, CRPO, and request to conduct inquiry against the incident and punish the corrupt who had tried to tarnish the image of Indian Railway. Sir, as a person of ordinary prudence, I have taken all the decisions for the benefit of railway, but within 6 months, I am again being transferred from NFR to SCR, since because of I did my work with full honesty, ethics, and dignity for the benefit of Indian Railway. I feel humiliated, demoralized. This resulted into mental trauma for my family members and will badly affect the mental condition of my children who recently got admission in their respective schools. Now, how this has been disposed?
It's very general statement.
My lord.
I denied the commission to own the boot laundry despite repeated requests of the firm. Which firm? Who are the persons?
My lord, by
Nothing
that is,
detailed.
that
A
is,
general allegation. Somebody has offered me and I denied that, and
My lord,
this has been
my lord, there are other
social media. Where is that social media? There is a campaign against me. Social media. What ultimately?
My lord, these are there. They cannot deny. If your lordship permits me, I'll file a detailed affidavit. What has happened there? I'm not bringing all this because ultimately this will lead
And
to a.
ultimately they have denied that we have not
My lord,
transferred
my
you
lord,
on account of that.
If I bring those allegations, your lordships are aware, man. If I bring those allegations here by way of an affidavit, this will amount to challenging the transfer order on the basis of malafide, malice in fact. That I cannot because I have not made them party. I
You
don't
are
want to make them
avoiding
party.
this, you are avoiding this because there is no, probably you don't have any material to challenge it on the.
Very well.
And it's unfair.
My lord, I'm accepting for the timing that there is no malice in fact because I have not made them party also. My lord, the way this representation was disposed of,
Yeah.
last 3 lines I will not read, my learned friend has read.
Yeah.
It shows and how ridiculously they have disposed of my representation. On the one hand, they prejudice me by transferring me out and I file a representation for recall of the transfer order. They say it is for your advancement of your career. It's a
That is their
ridiculous thing, my
view.
lord.
That is their view.
That is their view. But wait, in my humble submission, it is ridiculous. You are prejudicing me on the one hand by transferring me out, and then you are saying that you are being appreciated and this is for your benefit.
You are in this zone. How long you are in this zone?
My lord, this submission is absolutely incorrect. The transfer policy says not zone. It says station. My learned friend is developing an argument that if you are in a particular zone for 10 years, no, it says particular station. No, my lord, no, my learned friend is misreading the transfer policy. I'll show it to your lordship.
Sure.
Now, my lord may kindly see they're defending this transfer order on the ground of their ground, my lord. Lordship may kindly see. Their ground is that this is based on their own transfer policy. Lordship may kindly see what is the, I'll argue from their ground, my lord. Lordship may kindly turn to page 11, my lord. The first ground they have taken is they are relying on the transfer policy of 31/8/2015. Page 11, my lord, second ground. First one is the general ground, my lord. Page 11. I'll quickly go to the transfer policy, my lord.
Fine.
Roman 2, my lord, 11 Roman 2. The
Yeah.
said transfer was in terms of the comprehensive transfer policy for railway officers issued by Railway Board while later dated 31/8/2015. And there was no violation of a transfer guidelines, nor there were any allegations of any specific malafide intention made, etc. Then next paragraph, page 12, Roman 3, again that transfer policy of 31/8/2015. Now your lordship may kindly straightway turn to the transfer policy, man. Who is the transfer policy page? Page 104, madam. No, we 2018. Page 189, madam. This is their latest transfer policy. Which they have relied on in paragraph Roman 6, my lord, at page 17, they have relied on this.
Yes.
Page 17, Roman 6 ground, they have relied on this transfer. This is the latest one.
Yeah.
New Delhi, 14/5/2018. The transfer, posting, tenure of railway officers on zonal railway units, including posting in Railway Board and RDSO, is governed by instructions contained in Railway Board's comprehensive transfer policy dated 31/8/2015, followed by various clarifications issued thereafter. Instructions regarding procedure for approval of 189.
189.
My lord,
Yeah.
my lord, I'm sorry. First paragraph, I'm reading again, my lord. The lordship has got my page 189.
189.
Yes. The transfer, posting, tenure of railway officers on zonal railway units, including posting in Railway Board and so is governed by the instructions contained in Railway Board's comprehensive transfer policy dated 31/8/2015, followed by various clarifications issued thereafter. This is the document they have 31/8/2015 they have mentioned there. This 14/5/2018 also they have mentioned in the ground. Now, second paragraph. Instructions regarding procedure for approval of proposals for posting transfer were issued on 11/1/2018, followed by further clarification dated, etc., etc. Then the last sentence, my lord. Therefore, the following fresh guidelines are laid down only in respect of the procedure to be followed for approval of proposals for transfer posting of railway officers. Now they have given, I fall in category serial number 4, my lord. I am JAG, Junior Administrative Grade. And for me, if it is within the zone, the authority to approve the proposal is General Manager, GM.
Fine.
The third column is, my lord, interzonal. If it is interzonal, then the authority to approve the proposal is DG or member secretary. In our case, my lord, DG has approved. There is no issue, my lord. My submission before lordship is, my lord,
Not DG, railway member.
railway member, whatever it is, my lord, it is by the competent authority. My lord, my learned friend is arguing that it is the DG or the member who is to approve, he has approved. Question is not who has approved. Question is, where is the proposal? Before the tribunal also, I raised this plea and I filed specifically one IA, my lord, for production of records. That is mentioned in the impugned judgment, my lord, by the CAT. They did not produce the record. And I'll show from the document here, my lord, I filed an RTA application to produce that record to show whether there was a proposal and a recommendation.
So proposal from whom?
Proposal has to be from the placement committee. I am coming to that, my lord, next. That is why I say, my lord, that violation. Now, lordship may kindly come to page 104, because all these are, my lord, subsumed in this policy. Page 104.
Yes.
Page 104, 31/8/2015, that is mentioned there, my lord, lordship just now seen. It says comprehensive transfer policy for railway officer. Transfer policy for railway officers has been reviewed by the Ministry of Railways. In supersession of all existing instructions, Ministry of Railways have now decided to formulate comprehensive transfer policy for railway officers. The salient features of the comprehensive transfer policy are given in the succeeding paragraphs. Paragraph 1. Ordinarily, a Group A officer will not be transferred out of his allotted zone until selection grade. I have not attained the selection grade, so ordinarily they cannot transfer me. Now, lordship may kindly see Roman 7. Down below, my lord. Roman 7 says normally minimum tenure on a particular post at a time will be 2 years and maximum tenure will be 5 years. For sensitive post, maximum tenure will be 4 years. Minimum tenure will not be applicable for junior scale, senior scale officers of Group A. My lord, here I'll pause for a moment, my lord. It says minimum tenure will not be applicable for junior scale, senior scale. I am not neither junior scale nor senior scale. I am JAG. So this clause A7 will apply. My lord, on the first day when matter came up for admission, my lord, your lordship put me a question whether it applies to you or not. My lord, I was not having the proper instruction. I said no. Then your lordship granted the stay. Otherwise, your lordships were not pleased to grant a stay on that day. I made a wrong submission on that day because my instructions were not complete. Your lordship, I'm not finding fault with the court. I'm finding fault with myself. And I am finding fault with myself because there was inadequate instruction, my lord. And my learned friend is reading, my lord, the next paragraph, lordship may kindly see. Total stay at a stretch at a particular station should not be more than 10 years, and the total cumulative stay in broken spells should not be more than 15 years. My learned friend is relying on this to say, he has mentioned in the writ petition, my lord, that he has been in this zone for more than 10 years. It says station.
They are not relying on that.
No, they are relying.
On account of.
No, my lord, they are
They
relying.
that they simply say that minimum tenure has already been over.
In the zone, but it doesn't speak about zone, it speaks about station. In Guwahati station, my lord, I think it has been all 6 months only. In a normal case of transfer, I would not have challenged. I would have advised my client not to challenge it because you are liable to all India transfer.
However, in the administrative exigencies, relaxation may be granted.
My
by the
lord.
cattle controlling authority.
My lord,
So
they have mentioned here,
Relaxation.
there is no relaxation in this case. They cannot build the argument on the basis of relaxation because there is no procedure, no process followed for relaxing the rule, my lord. Now, lordship may kindly turn to page 108, my lord. How this policy was framed. First page 107, then page 108, my lord.
Yeah.
In fact, it starts the earlier one, page 108 is the first document, my lord, lordship.
Yeah.
I'm sorry, page 108.
Yeah.
10/6/2014. To the general manager, my lord. Implementation of Supreme Court's judgment dated 31/10/2013 in WPC number so-and-so, posting, transfer and railways. The Honorable Supreme Court in his judgment dated so-and-so in writ petition number so-and-so until directed that there should be a committee to be constituted at appropriate levels to decide posting and transfers of all Group A, B, and C officials, even if within the same zone. The posting or transfer to be regulated by transfer policies with assured minimum tenure. Policy provision may therefore be framed Now, 2 is important. Board has therefore decided that there should be placement committee to recommend transfer posting of all railway servants as per almost Supreme Court decisions. Following shall be the permanent placement committee. Now, committee has been for different officers, different committees are there. Now, Lordship may kindly see page 108, my lord. I'm sorry, page 107, man. I'm sorry, page 107. This is a letter of 7/7/2014. Implementation of Supreme Court judgment dated so and so. Please refer to para 2(1) and 2(2) of the board's letter dated so and so. For officers of the level of junior administrative grade, that is the respondent before your lordship panel, and selection grade in the zonal railways and production units, etc. These are the commitments. Competent authority, next paragraph, my lord. Competent authority. The competent authority to accept the recommendations of the above placement committee will be general manager, head of the organization. So there is a requirement of placement. I'm sorry.
If I may just add one small.
My
thing.
learned friend will get up.
Yeah,
Let me complete my lord.
Yes,
My learned
my lord, just one, just one small thing I want to add, my lord. These letters are, my lord. My lord.
Is that your transfer of the pocket is also in terms of the transfer?
Yes.
31.
My lord.
38,
31/8, my lord.
31 August.
8/15, my lord.
50. Now, where, from which provision of that
Policy.
relates to an interzonal?
My lord, that,
Because you have made a
My
capital
lord.
statement that you have made the transfer in terms of 31.
yes,
So which provision of that 31 facility interzonal? Because if
yes,
if the-
my lord, the,
that transfer is not, of a secretary officer is not going to be not till he makes the decision.
my lord,
How have you?
my lord,
And secondly,
my lord.
your that letter, Governor, regarding page 180, it says approvation
My lord.
is the member. Who has placed the matter before him for how the proposal for this?
That is my case. That is my case.
My lord,
These two points are not.
my lord,
Forget the.
my lord,
This is tribunal,
my lord.
that is on a different page. What he is trying to ask you is, where is that proposal? Who had done this? How did the member go thinking?
My lord.
Just do that.
Well, in that case, my lord, records may be called for, my lord. We'll place the records. We'll place
Because
the,
your specific case is that you have followed this transfer policy of 31st of August.
my lord.
The point which brother is raised is that first you show us where is the provision regarding interjournal transfer in this transfer policy and where is the proposal. These two things.
My lord. my lord, that 31/8/2015 guide, transfer policy was, my lord, further amended. My lord, page 189, 14/5/18 letter. My lord, this is in furtherance of that.
Right.
Yes. That
The
14/5,
basis of that, we are asking, where is the proposal?
yes. My lord,
Recently there,
my lord will take page 90.
recently your lordships have disposed of one case where your lordship has specifically held if there is no proposal, the transfer is bad. I have a division bench judgment,
My
By
lord,
this,
not by the division bench.
this is a,
I've given the cyclist to my.
this is a case of a
On
transfer.
this ground alone, this transfer order was interfered with. And my lord, I'm sorry.
My lord, in case of a group A employee, my lord, it is the railway board, my lord.
And my lord, this transfer policy was framed pursuant to judgment of the Supreme Court. Lordship, may kindly see two paragraphs.
that doesn't mean that it has a statutory force. They have
No, but I'm
simply
not,
said that.
no, I'm not saying statutory force. This Supreme Court case was filed by some IS officers to, Madam, I'm sorry,
You are referring to PSR.
my lord,
There is one notification with regard to infra-zonal committees are,
my lord, my lord.
but where is that notification pertaining to inter-zonal transfer? Where is that coming? Where is that, like that 1 year toner
My lord.
with regard to the inter-zonal? Intra-zonal, there is one,
Yes,
that is by the general, that is not pertaining to inter-zonal.
this present transfer is interjournal.
The notification committees that are here.
My lord, I've understood my.
That is for
Where
inter.
is that you're relying on that, show the committee which is there.
My lord, my submission is, my lord, the placement, it has to be recommended, but I'm just, my lord,
On the,
If there is nothing,
my lord,
it's only that 2018 letter which is there.
my lord.
Page 9191 is the recommendation by the.
My lord, assuming, my lord, I'll come to that. I have understood your lordship's question, my lord. Assuming that factually they have not considered that committee. Even then, my lord, in terms of the Supreme Court judgment and their policy, there has to be some recommendation or some proposal by. My lord, why I'm saying, my lord, there is a reason, my lord.
You have been before the tribunal,
tribunal even.
and the tribunal has also not considered that.
My lord, but
How
before,
can we
my lord,
do in his appeal on that?
my lord, before the, then, in that case, my lordship will dismiss their writ petition, my lord.
Wow.
My lord, my lord, the tribunal has found that there is a transfer policy, you have not followed that. My lord, even, my lord,
Where is that? Then show us the transfer policy provisions.
It's statutory.
my lord, in one paragraph, it has been stated to be statutory.
It is only the consideration. Otherwise, that malice or malefice is a very passing remark.
My lord, here is a case, my lord. I am, apart from this, my lord, I am also saying that because of the transfer policy, for not following the transfer policy, for which I have got a legitimate expectation, it has rendered the transfer order arbitrary. And the Honorable Supreme Court has made it very clear in 2 or 3 judgments, my lord. Hmm? No, no, you told me. It's been policy. 20. Please, please. আমার কথা তো।
Yes,
But if I may just clarify to that point, my lord, page 190.
yeah.
Since, my lord, I was submitting that the 14/5/18, my lord, notification is in continuance of the transfer policy dated 31/8/15 at page 90, clause number 2 in the note, my lord, if I may read.
Yeah.
In case of relaxation of provisions of comprehensive transfer policy, including note 1 above, approval of DG or member concerned up to SAG and of CRB for HA would be required.
First of all, you have to satisfy us that this comprehensive transfer policy is also in respect of interjournal transfers.
My lord, the comprehensive transfer policy says that ordinarily group A transfer will not be transferred out of the allocated zone. That can be relaxed, my lord, page 90, in case of relaxation of the provisions of the comprehensive transfer policy, approval of DG or member is required. That, my lord, records will reveal. And my lord, further at clause number 7,
There was an RTA reply.
Yes,
yes, my lord, that
RTA reply is there.
that is, my lord, in the
That
affidavit
you
in
have gotten
opposition.
fine.
My lord, regarding the issue of the placement committee, page 290.
Page 128, madam. 128. 128 and 129.
Where is this reply to 120?
128. 120 is the reply, ma'am.
128 is the reply.
My lord. Only one page. This is the reply.
But-
My lord, 129 is the forwarding letter. 120,
By the personal department.
my lord, my lordship may kindly see at page 29. My application was on 13/10/2023. Kindly refer to your RTA application dated 13/10/2023. And this is the reply they have given. 129 is the forwarding letter and 128 is their reply.
No. This kindly.
No, no, how can 120?
This is on 30th of October 2023, they are giving a reply.
Yes.
And this is the document, 120. 120 is the reply.
That is the recommendation of the board, my lord, where the signatures of the board members are there.
My
Secretary-
specific request was to please provide a copy of the recommendation of the placement committee. Lordship may still call for the record and find out, my lord. My lord.
And my lord, regarding the placement committee, my lord, page 292, my lord, will take my lord our affidavit, wherein during the pendency,
Call for the record,
Mal. Lordship will
my lord,
you produce the record, there is this relaxation part or whatever it may be, where there is a proposal for that.
I'll produce the report.
Because your transfer policy, ordinarily, a group A officer will not be transferred out of his allotted zone until till selection.
But my lord, in the administrative agencies, he can be. In the administrative agencies, relaxation may be granted, clause 7. And my lord, with regard to placement committee, my lord, at page 292, we have already seek a clarification that there is no, my lord, will take page 292. Page 292, my lord, there is no committee to recommend interjournal transfer
I
of
understand that.
group A officers, my
I
lord.
understand
It is
that.
on the recommendation of the cadre controlling authority. And my lord, so far as what are the, my lord, observations
call
of
for
the
the
cadre
report,
controlling
the
authority, my
lordship
lord,
is
that
satisfied, my
records we can produce, my lord.
Shows this record.
My lord, my lord.
Lordship will kindly mention that.
What?
They have to produce the record. That much only. Otherwise, on the next day, again.
No, I will produce it, no.
Because once from the record, if your lordship is satisfied, then I'll have no case.
Having heard the learned counsel to the parties that let deem it appropriate to direct we direct the counsel for the petitioner to produce the record pertaining to the transfer of the respondent number, pertaining to the interjournal transfer of the respondent number of the sole respondent.
So let's go.
List on
My lord, after 2 weeks, my lord.
gives the date.
19, my lord.
19,
My lord.
Let it be.
21, 21.
21, ঠিক আছে। Let it be 26, my learned friends. 26.
20.
Deep pure.
Item number 4.
Lord, on last hearing, my lord, my learned friend sought time to file reply and my lord, almost 6 weeks was given, but reply has not, my lord, we have not received.
Lordship, I'm extremely sorry, Lordship, actually, I could not give the proper instruction. Because they have
Your
said
headache,
that
madam.
my learned senior counsel has said that he is not challenging the termination order. Now he has pleaded some new issues. So which are not in the
Challenging the
pleadings.
termination order, what do you mean by not?
On the verbally lordship, they have made submission by learned senior counsel.
We are challenging the termination order, my lord, but we are not willing to take or taking back this contract, my lord. This contract has already been given to someone else. So we are not, my lord, on the point of getting back this, my lord. But the point is, my lord, because of this termination order, it is, my lord, akin to blacklisting. I am not able to participate for
Another.
any bid, my lord. So that is the only question, my lord, is to be decided, my lord. This was the statement made by the senior counsel, my lord.
When we are going to file reply?
Lordship, actually, I could not get the proper instruction. At least 2 weeks time may be allowed. Lordship, I'll try to file.
Huh? For last 4 months, we are not able to participate, my lord, because of this order, my lord. And I'm,
Because lordship in other
Lord, I'm coming from Delhi, my lord. At least you would have informed.
2 and 3. Raise some more time to file counter to the petition. In the interest of justice, last opportunity of
lordship,
how much?
2 weeks time as per his convenience.
Granted to file the counter
When
to the counsel for the respondent. This one.
date,
Lord, date, I'm coming from Delhi, my lord, so date may be fixed.
19th? 19th?
30.
19.
No, 19, my lord, I'm in Jaipur, my lord. 22nd.
22nd, hearing
Right.
day, we want to get it.
Thursday.
Hearing day.
This should be.
Tuesday or Thursday?
No, 25, 26,
26th
26.
26, deep privilege.
of life.
Item 7.
May it please your lordship. Lordship, here, after the directions of this honorable court, we had identified about 1,600 families. There was verification done. 928 families were identified, your lordship. Now, in our prayers primarily were with respect to issuance of ration cards, your lordship.
Not,
So,
this is not your primary prayer. Your prayer was that provide them food on account of this COVID conditions, they are not getting proper food and all.
yes, because we did not possess ration cards, my lord. So-
Ration cards, the process is going on, they'll do that.
Lordship, there is a directions issued by this honorable court in similar cases with respect to Kamrup Metro District. So in
Do not
similar
have any
lines,
ration card, issue ration cards to them. The supplies of food consumers.
so kindly grant us the liberty to make applications and thereafter the applications may be processed.
This is what,
My lord, this was the direction with respect to Kamrup Metro District. Similarly, we had come before this honorable court pointing out that people do not have ration cards and were not getting benefits during COVID-19. Thereafter, your lordship, the honorable court, we also said that about 110 applications had been made which had not been processed, my lord. So considering all that, from page number 12 onwards, this honorable court issued certain directions, my lord. Para 14.
yes.
May I read, my lord?
Having considered the
Submissions made by the learned counsel for the respondents, and on the basis of materials on record, it appears that some attempts have been made by the authorities, including the central government and the state government, towards resolving the issue involved in this PL. As far as grant of ration card is concerned, the needy applicants are required to follow the rules and has to apply in Form C along with the mandatory documents. As averred by the petitioner, in cases where verification has already been done, the authorities should process the same as expeditiously as possible. Grant of ration card requires individual competence for the same, and the rules thereof are strictly required to be followed. The authorities are also required to conduct survey as prayed for, and after identification of the beneficiaries, necessary steps for providing food grains under the National Security Act 2013 are required to be taken. As far as the period of COVID-19 pandemic is concerned, the affidavits filed by the Deputy Commissioner, Kamrup Metro, clearly indicates that adequate measures have been taken by the authorities, and in the light of the same, no further directions are required to be issued for distribution of food as COVID-19 pandemic has also eased out. However, considering the reliefs prayed for and having heard the learned counsel for the respective parties, in the opinion of this court, the following directions will subserve the interest of justice. Lordship, these are the directions. Number one, the respondent authorities, more particularly the Director of Food, Civil Supplies and Consumer Affairs, Assam, and the Deputy Commissioner, Kamrup Metro, are hereby directed to verify each and every application submitted for issuance of ration card as expeditiously as possible, and after due verification, pass appropriate orders for grant of ration card to such families who are found eligible in accordance with law. The respondent authorities are also directed to implement the provisions of the National Food Security Act 2013 in its letter and spirit, and to provide food grains to the poor households who do not possess ration card in accordance with law. The respondent authorities shall publish an advertisement in local newspapers informing general public as to who shall be the beneficiaries under the provisions of the National Food Security Act 2013. The respondent authority shall also notify the same outside every fair price shop, office of the district supply offices, and at prominent places for attention of public at large. The respondent authority shall take decision on the pending applications for grant of ration card as expeditiously as possible, preferably by 31/3/2023. Lordship, here also we will submit applications, my lord. So your lordships may give us that liberty, and accordingly these may be processed. Already more than 900 persons have been verified, my lord, by the respondent. 900 families. Persons verified by them are at case number 119.
You have already moved application or you are going to move?
No, my lord, here we were moving applications or applying before the Russian fair price shops, my lord. But they have pointed out that is not the competent authority.
Fine.
So they have said that the beneficiaries are identified in rural areas at the Gram Panchayat level or by the circle officer in the urban areas. my lord.
Fine.
So accordingly, we will file applications if
You'll file application.
lord. We were not applying before the appropriate authority. Indeed.
Yes. Who is appearing for that? You are appearing for?
I'm respondent number 5.
Who is the respondent number 5?
Nogam. I fail to understand why I have read it. I fail to understand.
There is nothing to do.
I'm still directly.
It is for the benefit of the lawyers also many a time. Yes.
The prayer, page 58, it says that we are to conduct a survey to issue ration cards who do not have ration. That is the prayer, page 28 of the lordship.
So ultimately, what's the directions which is seeking that if any such application is moved by them, the eligible persons
They will
will
be
consider
considered.
and proceed in accordance.
That's it,
And others are the general directions.
Lord. Lord.
This PIL petition is filed by the petitioners with the prayer to issue a direction to the Food and Supplies, Food, Civil Supplies and Consumer Affairs Department of Government of Assam to conduct a survey in the entire Nagaon district to identify poor households who do not have the ration card and to issue ration card to them during the course of this to them. Full stop. Ancillary reliefs of further prayers for ancillary reliefs have also been made in the writ petition. It appears that this writ petition was filed during COVID pandemic, and this court, taking into consideration the said fact situation, and noting the taking into consideration the situation that the marginalized and daily wage workers in district Assam are not able to sustain themselves in the pandemic, and therefore a direction was issued to the secretary, District Legal Services Authority, Nagaon, to conduct the survey and submit a report to the secretary, District Legal Service, to conduct a survey and apprise the deputy commissioner of its report, who shall then provide immediate relief to such families in the form of food and other daily needs. Full stop. Pursuant to that, the District Legal Services Authority has conducted a survey and identified 1,600 families who are eligible, who requires immediate assistance in the form of food and other immediate assistance. And pursuant to that, immediate assistance, full stop. From the affidavits filed on behalf of the Assistant Commissioner Naga, it appears that necessary assistance was provided to the marginalized, to the members of the marginalized society, including the daily wage workers in District Nagaon. Full stop. So far as regarding the issue of issuance of ration card to the eligible persons are concerned, the Deputy Commissioner Nagaon Relief and Disaster Management has filed an affidavit wherein it is mentioned that as per the National Food Security Act 2013, as per the provisions of National Food Security Act 2013, if the eligible persons whose categories have been whose category have been specified, full stop, applies, then the ration card may be issued to them as per the government norms. It is also stated that for getting ration cards under the NFSA 2013, applicant must be applied as per NFSA 2013 guideline and not through the local fair price shop. It is noticed that some of the petitioners and other similarly situated persons have applied for ration cards through the local fair price shop and not as per the NFSA, as per the provisions of the NFSA 2030. Full stop. Taking into consideration the fact that this honorable court, in respect of Kamrup district of the state of Assam, has disposed of a PIL petition number 32 of 2021, wherein also similar reliefs as prayed for in this writ petition have been prayed. We deem it appropriate to dispose of this PIL petition with the following directions, full stop. In case the petitioners or other similarly situated persons in case the persons belonging to the marginalized, belonging to the marginalized society and belonging to the categories specified in NFSA 2013 applies for issuance of ration card as per the NFSA guidelines. The Director of Food, Civil Supplies and Consumer Affairs, Assam, and the Deputy Commissioner, Nagaon, may verify each and every application submitted for issuance of ration card as expeditiously as possible, and after due verification, pass appropriate orders for grant of ration card to such families who are found eligible in accordance with law.
Lordship, I'm obliged. My lord, only one thing, if I may most humbly draw your lordship's attention to one aspect of the matter. My lord, there's not an averment stating that he's a citizen of India on the body of the petition, or there is no Aadhaar card also. Who this person is, my lord, is not known.
Since the court has already
It has,
entertained
but I just have
passed
placed it.
many orders, so without going into this technicalities, we are simply issuing, but
That is telling, my lord. Nowhere.
He's a lawyer, my lord.
Maybe, but it is not known through the petition. If you're a lawyer here in America, anywhere.
with these observations, this PL petition is disposed of.
Much obliged. Item 10.
Me. Made Mr. Lordship. Lordship, this is a writ appeal filed against judgment and order dated 19th of July 2021, whereby the learned single judge was pleased to dismiss the writ petition, Lordship. Lordship, the appellant, Lordship, who is an unbranched constable, Lordship, he went for a casual leave for 10 days, Lordship. Lordship, he could not join back his duty on time because in the meantime, Lordship, he was diagnosed with neurology, Lordship, a nervous disorder, Lordship. And in the meantime, Lordship, 2 show cause notices were served upon him, and finally,
Next, we are aware.
yes, Lordship.
Next, we are aware
Yes, Lordship.
how you have explained the delay in approaching the court.
Lordship, there's a delay in 6 years in approaching the court.
Why?
Lordship, I'll come to that, Lordship. Lordship was suffering from neurological disorder, Lordship.
Where is that proof?
Lordship, in the reply to the show cause notice, Lordship has been annexing page number 42, Lordship, 44, Lordship, 45, Lordship, 44, 44, Lordship.
44.
This is to certify that Sri Narendra Burman, aged about 57 years approximately, of so and so, has been suffering from.
Yeah.
So he has been suffering from neurological disorder, Lordship. And Lordship,
30-bedded rural hospital, Nalbari. Who is this person who has issued this certificate?
Lordship, by Deputy Superintendent Kakaya CHC Nalbari, Lordship.
Registration number, name, date. What is this? There is nothing, address, nothing.
Lordship,
How can we, this,
Lordship, the learned single.
nervous, nerve weakness, suffering from neuro weakness under my treatment from, that is from 10/12/2000 till date, 26. What is like this here? After 2014, okay, I find that yes, 2014, up to 2014, you were under treatment when your services were terminated. After 2014,
Lordship, that's the problem, Lordship. Lordship, he was suffering from neurological disorder and he has, and financially is not at all strong, Lordship. And he's an adult wife, Lordship, in his family, no other family members to approach the authority, Lordship. And Lordship,
after 20,
6 years, Lordship.
what
Lordship,
instigated you to approach this court in 2021?
but
Who prompted you or who this, encouraged you to do so?
Lordship,
Instead of filing an appeal to the authorities concerned, you immediately filed a straight away writ.
Lordship, as of date, Lordship, my grievance is that Lordship is not getting a pension, Lordship, after serving for 37 years, Lordship.
Now he is recovered from this.
Lordship, not totally, Lordship, but he's
Not totally, then how is he fit to be in the
Lordship,
courts?
Lordship, he's ought to have retired, Lordship. He's 64 years, Lordship.
36, 2000.
And Lordship, I have the medical certificate, Lordship, which says that he's still suffering from neurological disorder, Lordship. And Lordship, after rendering service for 37 years, for last 2-3 years of his service, Lordship, he could not return to his, he could not perform his duty, Lordship. That does not suffice that after serving for 37 years, Lordship, he's not getting his pension, Lordship. And it's very difficult for him, so Lordship, financially, mentally, and physically, Lordship, to sustain, Lordship. And in such a situation, Lordship, his rights will be violated, Lordship. And in the writ petition, Lordship, it was the merit of the case was not considered, Lordship. It was dismissed on the ground of Lordship, delay in lashes and acquiescence, Lordship. Lordship, and for delay in lashes, Lordship, Tarsan, Union of India versus Tarsan Singh was referred, Lordship. Lordship, in that judgment, Lordship, may be pleased to, Lordship, take up the judgment, Lordship, 2008, 8 SEC 648, Lordship.
Yes.
Paragraph 7, Lordship.
7. Yes.
Lordship, in paragraph 7, Lordship, it has been clearly stated, Lordship, it has been clearly stated that a belated service-related claim will be rejected on the ground of delay in lashes, where remedy is sought by filing a writ petition, or limitation, where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rule is cases relating to a continuing wrong. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy with reference to the date on which continuing wrong commenced, if such continuing wrong creates a continuing source of injury. But there is an exception to the exception. If the grievance is in respect of any order or administrative decision which related to or affected several others also, and if the reopening of the issue would affect the settled rights of third parties, then the claim will not be admitted in Lordship. Lordship, coming to the second condition and the third condition, Lordship. Second condition is that, Lordship, there should be continuing wrong. Lordship, there is a continuing wrong every day because, Lordship, he's not getting pension because of that, Lordship, of that removal order. Lordship, we are not objecting to that removal order, Lordship. We are objecting to the fact that after rendering for 37 years, and Lordship, second is that there should be an exception to the exception that, Lordship, if any third party is affected, Lordship, then belated service claim will not be acceptable, Lordship. But Lordship, in this matter, Lordship, in this case, Lordship, no third parties agree, Lordship.
Yes.
Without so, Lordship, the third condition of Tarsim Singh will be applicable in this case, Lordship.
Yes.
And Lordship, coming to the other ground, Lordship, of acquiescence, Lordship, the learned single judge stated that it is a case of acquiescence, Lordship. Lordship, inaction of any case does not lead to acquiescence, Lordship. It may be a case of inaction, Lordship, but not a case of acquiescence, Lordship. Lordship, in the instant case, there was no finality that he is not going to file a writ petition, Lordship. And also, Lordship, if in the case of acquiescence, Lordship, the burden is on the respondent's, Lordship. They have not proved that it is a case of acquiescence, Lordship.
Yes.
And the Lordship, coming to the Lordship, third ground, Lordship, the maxim vigentibulus et non dormantibus jura subventium was mentioned in the order, Lordship, which means that the equity aids only a vigilant and not the one who sleeps over its rights, Lordship. Lordship, the appellant, Lordship, is suffering from severe financial crisis, Lordship, and poor health condition. Lordship, he was not in a position to file a writ petition at that moment, Lordship. Neither physically, nor mentally, nor financially, Lordship.
Yes.
Lordship, we are not agreed by the removal order, Lordship. As of date, Lordship, we agreed that Lordship is not getting pension, Lordship, for the work which he had done for the last 37 years, Lordship.
Yes.
Case number 44 for timing.
44.
44. Yes. The last gentleman, now he improved and advised continued treatment and until further advice. That is, my lord, on 26/3/2014. And my lord, the removal is on 10/9/2014. After his improvement, man. But he still slips over his right.
Certificate is neither here nor there. Certificate.
That's right, man. Neither he can be called a medical document also. He sleep over his right foot 6 years, 11 months. And suddenly wake up on my 2021. No pleading to that effect, my lord. What prompted him?
That's it. Because all for order.
Item 11.
Mr. Goswami.
Yes, yes.
Uh, this writ appeal is against the order passed by the learned single judge.
Yes, bro.
While adjudicating a order passed by the industrial tribunal. We have a doubt regarding maintainability of this intra-court appeal. because what we feel that the learned single judge, while adjudicating the writ petition or while adjudicating the order of the tribunal, has exercised his power under Article 227 of the Constitution of India and not under Article 226. That is what
But I have not seen that, but the application, I think,
there are two reasons for that.
yeah.
First of all,
আমার 226, 227 আপনি yes.
this district tribunal has the tenets of a civil court. And the second is that these Guwahati High Court Superintendent of the Tribunal Rules 1992 specifically provided that in exercise of powers conferred by clause 1 of Article 227 of the Constitution of India, the Guwahati High Court makes the following rules. The rules shall be called Guwahati High Court Supreme Tribunal Rules, and the courts which are industrial tribunals, labor court, motor accident tribunals, etc. So as a matter of fact, we are exercising the powers under Article 227 of the Constitution of India while adjudicating the matters in relation to labor courts or industrial tribunals, etc. So you have to address on this point of all to satisfy us all.
I have not looked up that aspect.
Yeah.
I'll look up.
Yeah.
And there is one other thing also I should bring it to your lordship attention, which I did last time also. The main issue is whether this research institute is an industry
It is
within
still
the.
not.
Yes, and that is a matter which is pending before the 9 judges in the Supreme Court, because they have referred this matter because of some doubts in that Bangalore case on the point of industry. So this, as well as what your lordship has pointed out, your lordships can.
In fact, we have fixed some matters on 22nd of November. This industrial tribunal matters, we have fixed those matters for this arguments on the point of whether maintainability of the inter-court appeal.
I see.
So can also fix this matter on 22nd of November.
22nd of November, as your lordship pleases. I have not seen that aspect of the matter, nor was it raised in their.
No, it was raised, but in fact, it has came to our notice, so we thought we should hear them. It's on 22nd. You also come
So
prepare
for the
on-
award passed by the industrial tribunal, it is on final order. Against some final order of finality, only the reach is applicable. That is my humble submission.
You address
I will take it up. I have some doubt whether all the 227 is okay. I think only the read. Anyway, your lordship also you want to take that.
No, I have not seen this rule also. I'll look up, because we have all along been moving
Yeah,
to
that's
26
right,
against
but,
award,
it
because
was mine.
it's a writ of certiorari, which obviously has to be under Article 226. I'll look up this rule. Huh? 396. This was possibly through amendment. This,
Oh, it's old rule, 1992.
no, it has come by an amendment, I think.
No, not amendment.
Originally,
92 rules.
92, that's right. I am saying that not the original position. It has come
Maybe.
later.
Not the original.
It has come by amendment. Yeah.
Item 12,
Bibliography.
May I please, your lordship? My lord, petitioner wants to withdraw this appeal.
Withdraw, wants to withdraw, dismiss as withdrawn.
Item 13.
My lord, this matter will be fixed at two, my lord. Mr. K. Gogoi.
Two.
Yes,
Why?
my lord, actually, Mr. K. Gogoi will argue, my lord. He has just informed me over phone that due to some personal exigencies, he has to leave the court. He will come back before two, my lord.
Next week, like,
My lord,
next week.
next week, my lord, let it,
I
not
don't
be
know,
on-
26th November.
Like-
Item 15.
A general slip was circulated. In 15, a genuine slip was circulated.
By the respondent, my lord.
My lord, my sitting council, Armazon reach out of station. I pray for it.
Should have come in the morning.
Yes, I miss all.
Arjan.
Item 16.
Wait, your lordship. Well, in this petition, I have challenged the regulation which was managed for electrification, death of electrification. My lord, this regulation only, my lord, 4 lakh.
Huh?
Only this regulation, my lord, provided only compensation 4 lakhs, my lord, which is not just compensation, my lord. And I relied upon the, my lord, Supreme Court judgment, Raman, my lord, in which, my lord, the compensation was given to 60 lakhs. And some other judgment also, my lord.
Yes.
My lord. In this case, my lord, the four children, my lord, who are 6, 7, 8 years old, my lord, they were electrocuted, my lord, and it is, my lord, clear from the record, my lord, it was the negligence of the authority, my lord. There is no dispute on that, my lord.
There is,
No dispute on that, my lord.
what about not dispute about that?
Because, my lord, from the report, it is, my lord, confirmed that due to negligence of the authority.
Right, on the facts we are not going, how this policy is bad.
Lordship. Because, my lord, this policy only, my lord, 4 lakhs to be given, my lord. This is bad, my lord, because in, my lord, other,
Inadequacy of this compensation.
yes, my lord.
So on the ground of that, show us any law. This Raman deals with a specific case wherein the court, this single judge has allowed the writ petition, division bench has the reverse that judgment. Then the Supreme Court, in the facts and circumstances of the case, has granted this relief. How it is related to validity part, sir?
Lakshmi, can you see this in this judgment, my lord, all this discuss, my lord, Lakshmi, can you see paragraph 16?
Yeah, read.
Lordship. The learned single judge of the High Court has awarded compensation keeping all this aspect of the matter and has applied the guiding principle of multiplier method after awarding to the case of Sarala Bharma versus DTC for the purpose of computation of just and reasonable compensation in favor of the appellant, which method should not have been applied to the case on hand, particularly having regard to the statutory negligence on the part of the respondents in not providing the safety measure to see that live electric wires should not fall on the roof of the building by strictly following the rules to protect the lives of the public in the residential area. This court in Balram Prasad versus Kunal Sahab has deviated from the following multiplier method to award just and reasonable compensation in favor of the claimant in a medical negligence case. The same principle would hold good in the case on hand too. The following case law is followed by this court in the above referred case. The relevant paragraph are extracted herein to award just and reasonable compensation in favor of the appellant. Para number so and so. 3-judge bench decision of this court in Indian Medical Asan VP Santha, wherein this court has categorically disagreed on this specific point in another case wherein medical negligence was involved. In the said decision, it has been held at para 53 that to deny legitimate claim or to restrict arbitrarily the seize of an award would amount to substantial injustice to the claimant. In Govind Yadav versus New India Assurance so and so,
Just tell me, what is the ratio of this judgment, sir?
My lord,
Is that that policy for paying compensation was under challenge?
in this judgment,
Because in the facts of the case, it appears that there was no such policy, and therefore the person has approached the single judge or the High Court for the granting of compensation. Here they have a policy. How this policy is bad, the state or the authority or the this authority who has framed this policy has no jurisdiction to frame this policy, or what is this? So how much compensation you mean to say that apart from 4,000 instead of 4 lakhs, how much compensation is supposed to be mentioned in this policy?
Russia.
Kitna?
In this policy, my lord, given 4 lakhs.
They have given 4 lakhs again. You are proposing that no, it should be what amount should be paid?
It should be high because, my lord, in other case, in case of Motor Vehicle Act, my lord,
yeah,
there is a, my lord, specific formula is there.
Fine.
In railway, my lord, it is, my lord, enhanced to, my lord, 8 lakhs.
So different altogether different things are there, sir.
But in this case, my lord, Supreme Court, my lord, in similar facts and circumstances, my lord, when the
Similar facts and circumstances, do you show us whether there was any policy in that case
no,
for paying compensation or not?
But I am on the, my lord, just and, my lord, fair compensation, adequate
Sir, just
compensation.
and fair compensation, for that you can file a writ petition under Article 226, but how this policy is under challenge while this validity of the policy,
Lordship.
on what ground?
My lord, this is inadequacy of, my lord.
Inadequacy of compensation can't be a ground for challenge of the policy, sir.
My lord,
For
because, my
that,
lord,
you have to show incompetent, that the policy framers have no jurisdiction to frame it, or it is violative of one of the constitutional provisions. Where is that, sir?
my lord. So for the policy, my lord, in act, my lord, it is not, my lord, mentioned how much compensation will be, but as
Which
per
act?
Lordship, my lord.
Which act?
Lordship, may kindly see page 49 is the, my lord, the policy, my lord.
Fine.
It was, my lord, in exercise of power confirmed under section 181, one read with section 57(2) and the section 57(3) of the Electricity Act 2003. And all other powers enabling the this behalf and previous publication Assam Electricity Regulation Regulatory Commission hereby makes the following regulation.
So first of all, the authority is this under this powers conferred by Act of 2003.
Yes,
They have the competence to frame such regulations.
regulation, madam. They have.
So your challenge is not on that part that they have no, they are not competent to frame those regulations.
Yes, madam. That's the competence.
Now come to second part.
Yes,
Yes.
madam.
It is violative of which of the constitutional provisions?
Because, my lord, the section 57(2) and the 57(3) has not defined, my lord, how much the compensation will be, my lord. But that should, my lord, frame, my lord, the compensation which must be just and proper, my lord, adequate.
Just and proper, sir. What do you mean by just and proper, sir?
Because, my lord, in other regulation, in settle case, my lord, the compensation is, my lord, high, my lord. It's not, my lord, poor. Lord.
That maybe depends upon case to case, sir. But how this policy is bad? Because they have kept it open. And if you are not satisfied, you may approach the civil court for that purpose.
It is there in the policy itself.
My lord, civil court, my lord, this court has, my lord, I have some decision, my lord, this court and the Supreme Court has the power, my lord. When there is, my lord, the strict liability, my lord, Lordship may kindly see.
Sir, we are not here in adequacy of compensation to an individual. We are not considering that, sir. The division bench is here where you have questioned the policy itself.
Lordship.
So on what grounds you have challenged the policy, sir?
This ground is only, my lord, inadequacy of the compensation.
Inadequacy of compensation in case of individual is altogether different thing. Then you have to challenge or file a civil suit for that purpose, or you can approach the single judge for that under Article 226.
Earlier, they have some, my lord, notification. We have challenge also in this before the single judge, my lord. That notification, but when there is a, my lord, regulation is there, my lord. That's why we have, my lord.
Mister, if you are aggrieved by the inadequacy of compensation, either you file a civil suit or you can oppose the writ court. Not by challenging this regulation itself, sir. You are aware that validity of this enactment can only be challenged in two conditions.
Okay.
That it is in violative of this chapter 3rd of the Constitution, or incompetence of the framers of that policy, or violative of any of the constitutional provision. Which is that, sir?
Lordship will grant some time, my lord, on this point, my lord.
May I indicate one thing, my lord? Page 59 of the policy itself says, my lord, page 59, my lord, of the appeal memo, my lord. The policy under attack itself says, my lord, clause
Yes.
20, clause 22(2), small Roman 2. Notwithstanding the above, the aggrieved person may approach a civil court.
Yeah, that is the-
So we are giving 4 lakhs as a whole to everyone, my lord. Beyond that, if somebody has a further claim, my lord, of compensation establishing negligence, he can go to civil court at any time, my lord. Itself, my lord, saving clause is there, my lord, page 60. Page 60 is the saving clause, my lord.
Yeah.
Next page 26 is the saving clause. The provisions of these rules shall be in addition to and not in derogation of the provisions of any other law, rules, or regulations of scheme or contract for a time being imposed. Notwithstanding in these regulations shall be deemed to limit or otherwise the effect of inherent power of the commission to make such orders as may be necessary for meeting the ends of justice or to prevent the abuse of the power of the commission. So generally, my lord, 4 lakhs we have fixed depending upon our financial capacity, my lord. If somebody is aggrieved in a given case, it might go to crores, my lord. It might go to 50 lakhs.
My lord, one judgment, my lord, that is 1993 to Supreme Court, cases 746, my lord. There are 35 says, my lord. This court and the High Court, being the protector of the civil liberties of the citizen, have not only the power and jurisdiction, but also an obligation to grant relief in exercise of jurisdiction under Article 32 and 226 of the Constitution to the victim or heir of the victim, whose fundamental right under Article 221 of the Constitution of India are established to have been flagrantly infringed by calling upon the state to repair the damage done by its officer to the fundamental right of the citizen, notwithstanding the right of the citizen to the remedy by way of a civil suit or a criminal proceeding. The state, of course, has the right to be indefinite in my lord. I understood that point, madam.
Saying that you're not right to an aggregate or that.
Madam.
You're right.
Madam.
But the challenge of the present process is that regulations of 2000.
Lordship.
We find that regulations to be not required to be interpreted. So you have any judgment to that effect, that the regulation so framed is bad, cannot be framed is correct. So that. Whereas
Lordship.
compensation is there, either in both code and civil.
Lordship.
Already open, civil suit. Or if permissible, a writ petition. But here, the first challenge is prior day, 2019. You have to satisfy us that regulation is not. And not on the ground that it will be inadequate. It has to go beyond that. Competence, as my lord has said, competence,
Lordship.
right? Violation of part 3 of the Constitution.
Lordship.
Or even the electricity. Act. But not about the
So in this point, Lordship, I need some time, my lord. After 1 week.
It is.
After 8 weeks. No date. Item 18 to 20.
Yes,
Good afternoon, my lord. My land was illegally acquired in the year 2010 by the respondents. And in the process, they did not follow the law. And then we were asking for 30% solicium at that time. After many applications, after many denials, even after the passing of the new act, 2013, we applied for solicium of 30%. And then when there is no more response, we were helpless. After all options were exhausted, we applied for compensation under the new act. We prayed for declaring that accusation, that illegal accusation, was null and void, and to invoke the 2013 fair compensation that came into effect on the 1st of January 2014. And we also prayed for enhancement of compensation as on the day the Lordship passed an order, judgment order, for ends of justice. There in the synopsis, I have written very elaborately.
In which case? There are three relatives.
Yeah, the first one is 151.
You are in 1/5.
151,
You are appearing in 1/5.
151, 152, and 154, Lordship.
You are appearing in all the three.
Yes, Lordship. They're all analogous cases.
So your all the three petitions connected by the order under appeal.
Yes. Single judge in either bench. Unfortunately, the single judge failed to give our prayers to declare the compensation, the accusation as null and void in the first place, and to give us fair compensation under 2013, and to give us enhancement.
So towards property record that in WPC number 140/2019 and 149/2015, you had land parcels for that. Any parcels?
In this case, in this 151, we don't have land records. We don't have land records. Having said that, they have destroyed our residential areas. They have destroyed our crops and plants. For that, they gave us some money.
You have not disclosed that. You did not disclose that before the Learned Single Judge when he filed the report.
No, Lordship, I have disclosed everything. This case is filed in the year 2014. And now it's 2024. We have, in fact,
yes. Yes.
Yes, Lordship. So aggrieved of the order of the single judge, we have filed this appeal here with the permission of this honorable court. So today, we are still saying the same. There are land was acquired illegally during peacetime, even not during the wartime. Then even the then BDO, who was in charge of the negotiation, admitted that we have to be paid 30% of solution. That also is not paid. And then when the new act came into force, we were helpless. We still paid for 30%. And finally, when all options were lost, we filed this writ petition 2014.
Fine.
Yes. Yes,
There is our prayer, Lordship.
okay. Yes, that's all.
Yes, Lordship.
In my humble submission that the appellant hearing do not have any land process or mining process. They could not produce it before the deputy commissioner or not produce it before this honorable court. And moreover, as they were occupying that portion of land, they are their cultivation and some built structure. They were assessed jointly with the presence of the occupants, the appellants, and compensation was assessed and paid. And without any objection, they have received that compensation. Thereafter, coming into force of this 2013 Act, they came before the court that earlier acquisition process to be declared as null and void, and fresh acquisition process to be started under this Act. But earlier, they do not have any objection, they accept this. And therefore, this honorable single judge has dismissed this petition. And they don't even disclose about the receipt of the compensation before the single. So there is no infirmity in the judgment. Even the deputy, case number 95, the order of the deputy commissioner, what they have challenged before the honorable single judge, there was specifically mentioned about that. The petitioner did not possess any land purchase or mining purchase.
Lordship, will you please turn 144? 144. Para number 4. May I read?
Yes,
The petitioners were given nominal amount by the respondents. Where is how come they say that we have not said anything about our getting the money? We have been given nominal amount, we have admitted. Thereby reasonable compensation was denied to them as per Land Acquisition Act of 1894. The amount so given by, to them is given in the chart against each of their names. And the chart is here at page 82, 182.
Yes.
And here they used the chart, dubious chart for compensation of crops and plants. They even don't use their own gazette.
Yes.
That their dubious chart is in 160 for compensation of crops and plants. And then the compensations given to them is here in 182. Hence the gazette notification issued by them is 167. So when all these materials have been placed before them, they still go on trying to mislead the court.
Yes.
So we want justice, Lordship.
That's all.
Yes.
That's all. What are the Yes. You get two.
Item 21.
My lord, the learned friend has been asked to submit their all the judgment of surfacing. So my lord, on last occasions, my learned friend has submitted that if this limitation is allowed by the Channel Court, then that there will be, they'll open a floodgate. All the person will come over there, and then there's a matter of, now if, even if we don't allow, then the Article 236, anybody can come. This is judgment of the High Court. If anybody, if it's not allowed, then anybody can come here also for 220, under Article 226. As observed by the Honorable High Court. And my lord, your lordship has said that you want to analyze all the judgment. So, first judgment I'm taking a Balester Dial judgment. Lordship is relevant para, I'm just reading, para 7. Yeah, page 7, para 7. The first point for consideration is the application of proviso to the section 23 of the Red Act to the disposal of appeal by the appellate tribunal. Section 23 says about that power of the tribunal for granting of limitations. What the 23 says. Every appeal under section shall be filed within a period of 30 days. The date on which a copy order made or deemed to have been.
reading?
Page
But the first point.
appeal, recovery, Red Act, recovery date and bankruptcy act. Section 20, subsection 3.
Yeah.
It's written clearly that every appeal under subsection 1 shall be filed within a period of 30 days. The date on which a copy or order made or deemed to have been made by the tribunal.
Sir, read from the
Pardon?
read from the.
You read first para.
Yes, para 7, yes. I'm just saying, the first point for consideration is the applicability of proviso to the section 23 of the Red Act. To the disposal of appeal by the appellate tribunal under section 82 of the Surface Act. That is that means they want to distance. Yes. A bare perusal of the set 18 made it clear the appellate tribunal under Service Act has to dispose of appeal in according with the provisions of RB Act. In this respect, the provision of RB Act can incorporate in the Service Act for disposal of appeal. Once it is so, we are unable to discern any reason as to why the Service Appellate Tribunal cannot entertain appeal beyond the prescribed period even on being satisfied that there is sufficient cause for not filing such appeal within that period. Even if the power of condemnation or delay by virtue of section 29(2) or limitation were held not to be applicable, the provision of section 23 of RB Act is applicable by virtue of 18(2) of the Service Act. So, Lordship, if you Lordship read the 29(2), the interpretation is clearly borne out from the provision of 2 statute and also advance the cause of justice. Unless the scheme of statute expressly excludes the provision of power of condemnation, there is no reason to deny such power to the appellate tribunal when the statutory scheme so warrants. Principle of legislation by incorporating a well-known and has been applied inter alia in Ramkripal Bhagat versus State of Bihar, Bolani and others versus State of Odisha, Mahindra Limited versus Union of India, and Onkalal Nandalal versus State of Rajasthan, relied upon on behalf of the appellant. We have thus no hesitation in holding that the appellate tribunal under the Service Act has the power to condemn the delay in filing an appeal before it by virtue of section 82 of the Service Act and provision of section 23 of the RB Act. But here says the Service Act, in case of Service Act, in case of appeal, it is allowed. The fact that the RB Act and Service Act are complementary to each other, my lord, is very important. Is interrelated. As held in Transcore versus India, we now deal with the conflict views of the High Court on the subject. The Madhya Pradesh High Court has held that the power of condemnation delays to exclude by principle of interpretation that if a later statute has provided for shorter period of limitation without express provision of condemnation, it could be implied that there is no power of condemnation. Reliance has been placed on principle of statutory interpretation by Justice G.P. Singh. It was further observed that limitation was made applicable to a tribunal under section 24 RB Act, but there is no similar provision with respect to appellate tribunal. To justify such interference, reliance has been placed in Gopal Sardar case, and so. It is further observed that the object of Service Act was to ensure speedy recovery of dues and quicker resolution of dispute arising out of action taken for recovery of dues. We find that approach to be erroneous and incorrect, understanding principle interpretation, which has been relied upon. The principle discussed in the celebrated treatise in question as follows. 15. When an amendment act alters the language of principal statutes, the alteration must be taken to have been made deliberately. It is difficult to appreciate how the above principle justify the view of High Court. The change intent in the Service Act has to be from the statute and not from beyond it. No doubt, the period of limitation for filing appeal under Section 18 of Service Act is 30 days. As against intent may be deliberate. As intent under 45 under Section 20 of RB Act. To the extent the legislature intent may be deliberate. The absence of express provisions for condemnation delay Section 82 expressly adopts and incorporates the provision of RB Act, which contain provision for condemnation of delay filing appeal. Cannot be read as excluding the power of condemnation. As already observed, the provision of Section 23, which provides for condemnation delay of 45 days under RB Act, extend to period of disposal under appeal under Service Act. To the extent that the condemnation is delayed beyond 30 days. There is no reason to exclude the provision of Section 23 dealing with the appeal under Service Act. Taking such a view, with the nullifying section 18(2) of the Service Act, we are thus unable to hold the view taken by the Madhya Pradesh High Court. We approve the view taken by the Madhya Pradesh and Andhra Pradesh Bombay High Court, but for different reasons. The view taken by Andhra Pradesh High Court is based on applicability of Section 29(2) of the Limitation Act. That means they have given emphasis on 29(2) Limitation Act. In our view, Section 29(2) Limitation has no absolute application as the statute in question implied exclusively applicable to provision of Limitation Act. To the extent the different scheme is adopted, if no provision of Limitation Act was actually adopted, it has been possible to hold the virtue of Section 22 power contention delay was available. It is well settled that exclusion of power of contention delay can be implied as laid down in Union India versus so-and-so, relied upon on behalf of the bank. We have now averted to the last question as to whether the appellate tribunal under Service Act was
not a court. Therefore, section 22 of limitation was not attracted. The Honorable High Court in Sajada holding that tribunal to the court under section 22 and 24 of the Act. Section 22 vests power of civil court in tribunal only for purpose mentioned therein. As such, summoning witness, discovery and production of document, evidence, issuing commission of witness, and deems the tribunal to the court for specific purpose. Such as for section 193, 193, 228 of Penal Code and 195 Criminal Procedure Code. This provision may be excluded conclusive. This provision may conclusive of question of tribunal being court for section 22 of Limitation Act. Without further examining the scheme of statute in question, so and so this court examined the scheme of 2 acts in question and held that the tribunal was a court, but not a civil court for the purpose of section 24 CPC. We are of the view that for the purpose of decision of those appeal, it is not necessary to decide the question whether tribunal under the banking statute in question is court for the purpose of section 22 of Limitation Act. We have held that the power of condemnation delay was strictly applicable by virtue of 18 of Service Act, deadly provision of section 23 of the Act. And to that extent, the provision limitation has been expressly incorporated under special statute in question. Section 22 stands implied excluded. To this extent, we differ with the view taken by Andhra Pradesh High Court as well as the Madras and Bombay High Court. We are also in agreement with the principle that even though section 5 of the limitation may be implied inapplicable, the principle of section 14 of limitation can be held to be applicable even if section 29(2) of limitation does not apply. Because if 29(2) is not applied, 14(3) is applicable. Limitation says that as a result of the above discussion, the question answered in the affirmative, this is important. This is the last, by holding the delay in filing appeal under section 81 of Service Act can be condoned by the appellate tribunal under provision of section 23 of the Act. Read with section 18(2) of the Service Act. The contrary view was taken by the Madhya Pradesh High Court in said Banshidhar Kolita for Kedia Rice Mill Private Limited is overruled. Accordingly, the appeal filed by the bank against the judgment of Andhra Pradesh High Court is dismissed, and the appeal filed by the borrower allowed. The impugn order passed by the High Court of Madhya Pradesh, appeal number so and so, SMP so and so, are set aside, and the matter demanded to High Court for being dealt with afresh in according with law. The appeal arising out of SMP so and so has been preferred directly from the order of the tribunal passed by the said tribunal, relying upon judgment of Madhya Pradesh High Court. The said impugn order is set aside, and the matter is demanded to the tribunal for being dealt with fresh in accordance with law. So this judgment says that as per provision of Red B Act, my lord, when a Red B Act can, there is a provision under Limitation Act, why not applicable in Service Act? That's why they come to a conclusion that in case of appeal, the Limitation Act can apply. So, my lord, so this judgment yes. So, my lord, this judgment, here as per this judgment, appeal file under Service Act is allowed. You can file a provision for delay of limitation. You can file a petition for delay of limitation, and court can condone it. But thing is that, my lord, this judgment is again challenging the Supreme Court in KL George. Section 17. And what does, section, if you actually go through the page 12, page 11, the learned counsel for the petition submits that the principle underlying the decision is CA, so and so title of Balasada judgment versus Bank of India.
That is pending consideration.
Yes, pending consideration, and one observation has been made that dealing with section Surface Act and IDBI must be applied to dispensation provision section 77 being similarly worded. That means what are the things they written in the IDBI Act should be similarly worded. This observation has been made, and this is under pending under considerations. And now, my lord, if you also go to page 19, there is another judgment where says that even if nothing, if now no alternate remedy, only the alternate remedy is 29(2) of the Limitation Act can apply. And observe, if you also go to the there's a Madhya Pradesh High Court judgment. In my synopsis, in
Madhya Pradesh judgment was under taking into consideration the provisions of section 29(2).
Yes,
They said the Surface Act or section 17 doesn't specifically exclude the Limitation Act, and therefore by virtue of section 29(2).
Yes. This observation has been made in.
Yes.
Now, my lord, in the tribunal, Deputy Guwahati, why he has rejected my claim? Because of accept commercial pending in the High Court in Calcutta, that is the judgment given by Calcutta High Court in accept commercial. Private limited, 89, page 18 of 102. This court, Calcutta High Court has observed that since it is a civil in nature, it is a civil court, and in the initial stage, no appeal, there can be ground for any limitation. And this judgment is based on the basis of Madhya Chemical judgment. Madhya Chemical judgment, if you also go to the Madhya Chemical judgment, I'm just shortage, I'm telling you, in Madhya Chemical judgment, yes, court says it is civil court. It's not a civil court, it's initial proceeding, but nobody has stated that there is no ground of limitations. No, there will be no ground for that you can file a delay petition for condemnation delay petition. It has not yet been observed by the Madhya Chemical judgment, my lord. The full bench judgment. And page 127 of the Madhya Chemical judgment, if you go through the page 127, you will find that relevant portion, my lord.
Yes.
Yeah. The 3-4 judgment very important. The another judgment, my lord. In porous laboratory judgment, my lord, is a clear cut given. Yes. Section 17(7) of the Surface Act specifically deals with Section 17(7). If you have to go to Section 17(7) of the Surface Act, here it says that while dealing with the provision of services, you have to take the help of the RDB Act, RDB Act, where
yes.
In safety, if you have to go to Section 17(7), my life will also give to Section 77. Same as other provided by this Act, the debt recovery tribunal shall may dispose of an application of servicing according to the provision of RDB Act and Financial Instrument Act and the rules made there. They specifically mentioned that if they know that the RDB Act will apply, you have to take. There's no way that lawmaker, that the legislature is given some relief to the borrower. It didn't know 24. Opposition.
So, my lord, this. Yes, Yes.
No, my lord, 77 is clear. And just like to point out one other thing in Review Act, section 24. Section 24 says about the limitations.
Yes.
Is given the limitation, the provision of Limitation Act shall as far as be applied to the application made to a tribunal. So it is clear that there is a provision for tribunal. So this is an old act, sufficient new act. That's why, my lord, I just read out that interpretation of incorporation of earlier act into later. Incorporation of earlier act into later act is a legislative device. Advocate for-
Where are you reading?
it is Ram Kripal Bhagat versus State of Bihar.
Citation.
Citations. AR 1970,
You
SC
should have
951.
supplied us the copy.
That copy, I have not got it. But if Lordship, I can give you this book, sir. You can read it, my lord.
You should have supplied the judgment, sir. Books, how can we go into?
Judgment of California.
एक copy है सर।
Put on it. The copy will put it.
Instead of referring to this.
No, no, I know.
judgment निकालना चाहिए था ना, sir.
And a copy दिखा देगा आपको, if you Lordship, but I can give you a copy.
This is absolutely, so refer to the.
Because यहाँ बताया जो if whenever a new old
Understand that, sir, but the proper course is to place the judgment before the court.
yes, no, no. Yeah, no, yeah.
This can't be the way.
कोणती ओंडा ओंडा कुठं किती खतरा कॉन्सिक्वेंस दिला तो बोला ना की
Yes.
My lord, just bringing the judgment and one another judgment, my lord. I've stated in my judgment synopsis I've given that Porous Laboratory Private Limited, page 21 of my judgment citations, compilation of judgment citation, page 21. Page 21,
Hyderabad.
Hyderabad. Why it is important, my lord? Here similar case happened. So Calcutta DRT is the first which is where is the alternative remedy. Here they have dismissed my petitions. No. Since they are bound by the Calcutta High Court judgment after commercial, DRT says no, we will not allow. No limitation. So here that's why he has filed an application before the Hyderabad High Court. Hyderabad High Court has reversed the judgment, not reversed the judgment of Akshay Kumar, but given some view, which is in paras 17, if I read from para 17, page 27.
Yeah.
I just read out, my lord. Further, The recent judgment of Supreme Court in International Asset Reconstruction Company of India Limited versus Official Liquidator is also a guidance. In this case, the issue raised was that whether Section 5 of the Act could be invoked to condone the delay of present day appeal under Section 31 of the 8B Act before the tribunal against the order recovery officer. An appeal under Section 35 of the 8B Act normally has to be preferred by aggrieved party before the tribunal within 30 days. The argument advanced before the Supreme Court was that the virtue of 29(2) of the Act, the Provisions Limitation Act, the provision of Section 5 therefore could be made applicable to a belated appeal filed under Section 30 of the 8B Act. Supreme Court, however, noted that application B as defined under Section 2B of the 8B Act was only the application filed under Section 19 thereof. And also the tribunal cannot condone the delay unless expressly confirmed with such power by the statute. Observing that the application of 8B Act is one made under Section 19 thereof, an appeal would be lie against the order passed by the tribunal, the appellate tribunal, Section 20 of the 8B Act. The Supreme Court noted that specific provisions were made for condonation or delay in presentation of such an appeal beyond the stipulated period under provision of Section 23 of the 8B Act. However, when a person is aggrieved by an order of recovery officer, he has to prefer an appeal before the tribunal, Section 31 of the, and this appeal is distinct and separate from the appeal preferred before the appellate tribunal, Section 20. The Supreme Court pointed Section 24 of the 8B Act manifest made the provision section of the Act of 1960 applicable only to original application. And the same could not be extended to the appeal filed on Section 30 of 8B Act. It was ever concluded the scheme of 8B Act made it clear that the legislature provided for application of the Act to original application before the tribunal under Section 19, and the appellate tribunal has conferred with power to condone the delay under Section 23 of 8B Act. Application Section 5 of the Act to an appeal under Section 30 of the 8B Act by taking recourse to Section 20 into Act was therefore held to be improper. Though the above judgment dealt, this is the observation, though the above judgment dealt with the provisions of the 8B Act, the Supreme Court categorically held that therein, by the virtue of Section 24 of the Act, would have been application to original proceeding before the tribunal. In consequence, there can no doubt that a belated application of Section 17 of the Surface Act, being one of such of original application before the tribunal, would attract the provision of Section 5 of the Act. Here says that this is the original Act, but what says Section 17 and Section 37 of the Surface Act, 70 subclause 7 and the Section 37 of Surface Act, read with Section 24 8B Act. Earlier, the Madras High Court also had that effect in so there they need to point out Section 17 of Surface Act did not stipulate any outer time limit for the tribunal to condone the delay, as in other enactments where the power to condone is restricted by further time limit. They were referring to Section 77 of the Surface Act. The Madras High Court extended Section 24 of the 8B Act to application of Section 17 of the Surface Act and held that the Section 5 of the Act would be applicable to such an application before the tribunal. More importantly, it may be noted that if an aggrieved person, including a borrower, is prevented from availing the statutory remedy provided under Section 17 of the Surface merely because the application was not presented within a stipulated period of 21 days, the hierarchy, 45 days, the hierarchy of remedy provided Surface Act would be denied to him and render nugatory on the shorter ground. Such an aggrieved person would be therefore left with no other alternate remedy but to invoke the extraordinary jurisdiction of High Court under Section 226 under Article 226 of the Constitution. As the very purpose of creating statutory tribunal and appellate tribunal is to provide efficient alternate remedies of jurisdiction dispute so as to lessen the burden that would otherwise be visited upon the High Court to exercise our extraordinary jurisdiction on Article 226. The statutory remedy provided under Section 71 of the Surface Act cannot be interpreted in such a narrow and arbitrary compliance. Being noted by virtue of provision to Section 23 of the 8B Act, the appellate tribunal has been held to have the power to condone the delay in presentation available under Section 18 of Surface Act beyond the 13 days before stated. There is no logic or rationale. This is important, Mala. There is no logic and rationale in not extending the same power to a tribunal while entertaining a belated application of Section 17 of the Surface Act. By taking recourse to Section 17 and Section 37 of Surface Act, that be Section 24 of the 8B Act.
Yes.
Yeah, all application emphasis have been given of Section 17, Section 37 of Surface Act, and Section 24 of 8B Act. On the above analysis, this court finds that the law laid down by the Calcutta High Court in Akshat Commercial Private Limited does not constitute good law for the reasons stated above. And in the light principles paid out in the Supreme Court Balasar judgment, just well as the International Constitution Company The power provision of section 5 of the Act would therefore be much applicable to the application filed before the section 17 of the Surface Act. The tribunal held so far that the tribunal seems to have been misguided itself by the strength of decision of Calcutta High Court. Further, as the application filed by the petition company before the tribunal under section 75 of the Act, the mere fact that it projected section 20, section 14 thereof before the appellate tribunal did not dilute the character of condoned delay filed before the tribunal. As the tribunal has found in fact that the petition company did not make any sufficient cause for condonation delay in the presentation of appeal under section 17 of the Surface Act, the appeal by the appellate company before the appellate tribunal necessarily required adjudication on this aspect. However, the appellate tribunal did not adjudicate upon the finding of the tribunal as to the petitioner company failing to sustain sufficient cause for condemnation delay section 5 of the Act. As this was the subject matter of appeal and the appellate tribunal failed to take note of the same and adjudicate according to the order passed by the appellate tribunal and appeal was set aside and the matter is limited to the file of the appellate tribunal of Calcutta for consideration afresh of the appeal on merit, keeping in view the observation made therein. So here says, my lord, the Akshay commercial judgment of the constitutional good law, and then the matter has been referred back to the tribunal, appellate tribunal for fresh adjudication. So even if I go to appellate tribunal, Calcutta, they will reject my petition because they have no jurisdiction. Because Calcutta High Court has a jurisdiction over the appellate tribunal. But if this order passed by the Guwahati High Court, this order will be bounding upon the Guwahati tribunal and other Northeast tribunal. Only one tribunal, Guwahati. So, the next judgment, my lord, P.K. Radhakrishnan was a bit. P.K. Radhakrishnan was the Central Bank of India. That is, my lord, my compilation in number 5 judgment. The Honorable Madras High Court has held that section 36 of Survey Act does not specifically exclude the applicability of the Limitation Act in the proceeding institute of the Survey Act. Those says that section 36 specifically prescribes the claim of subscribed creditor within the period of limitation prescribed under Limitation Act. If you also go to the page 30, page 30. Very big judgment. So, my lord, I just read this page 39, my lord. 2 paragraphs. Page para 18, my lord.
Yes.
A comparison of section 17 and 18 of Surface Act would reveal that the provisions are almost similarly worded. That means it is similarly worded. This is also application. That is also an application. They are defined under ADB Act, is section 2. What is the applications? Section 36 of the Surface Act speaks about a limitation, and it says no secret creditor shall be entitled to take all or any of the measures under section 4 of the section 13, unless his claim in respect of financial assets is made within the period of limitation prescribed under Limitation Act. If the submission of the learned counsel for the petition and WPC so and so is accepted, section 36 should be worded otherwise, be totally excluding the applicability. In the considered opinion of the court, the division bench of Honorable High Court, Andhra Pradesh High Court, in the decision report is in so and so, online so and so, have taken into consideration the judgment in Baleshwar case. Okay. Yes. So, my lord, I have given the judgment of intervention statute, my lord. Just now I've given, my lord, that Ram Gop Kirpal Bhagat. Yeah. That judgment to judgment. Para 18, my lord.
Yeah,
Para 18, yeah, mark. Para, from, if you also go through the para from para 18, last later part of para 18, the answer is there.
para 18.
Para 18, page 41477.
Read.
Yes. In the present case, subsection 2 of section 3 of the Import and Export Control Act enacts that goods to which any order under section subsection 1 applies shall be deemed to be goods of which the import or export has been prohibited under section 19 of the Sea Customs Act. And the second limb of subsection 2 of the section 3 is all the provisions of the act shall have effect accordingly. To accede to the contention of counsel for the appellant that only section 9 of the Sea Customs Act will apply, 1970 will apply, and no other provision of Sea Customs Act will be effective or operative, will be not only to the render the words and all the provisions of the act shall have the effect only, obligatory but also negatory. When the statute enacts that all the provisions of the act shall have effect accordingly, it will be an error to hold in spite of the language of such legislation. The provision of Sea Customs Act shall not have any effect. The effect of bringing into act the provision of earlier act is to introduce the provision of bringing, this is important, my lord, from here started, the provision of bringing into act the provision of an earlier act is to introduce in the incorporated section of the earlier act into the subsequent act, as if those provisions has been made enacted in for the first time. Nature of such piece of legislature was spent by Lord Isher MR in rewards, etc. If some clause of the former act were brought into the subsequent act, the legal effect was to write those sections into the new act, just as they have written in with the same pen. This is interpretation statute, my lord. Section 77 and 24. Yes, yes, yes. Just the interpretation is that whenever the new act comes, if the older act is there, that wording has to be followed. Accepted 17, This is the interpretation of statute. So I'm coming another judgment, if your lordship, the Patna High Court judgment.
Okay, all this, relying on the other judgments they are holding, yes, we understand that.
Yes, all the judgment which I have quoted, my lord, in the compilation, this all says that no, section 5 or limitation.
That you have made, is in this compilation, these judgments are already there.
Yes, yes, already.
We'll consider it.
We will go.
Yes. Yes.
May I please, Your Lordship? Before my lord takes to the judgment which I have relied upon.
Yeah.
My lord, the purpose of the Surface Act for which the act has been brought into force is very much specific in the renowned judgment of the Honorable Apex Court, which is, my lord will find it at page 66 of my judgment. The reasons for enactment of the NP Act. 66, interior page. I've done pagination.
66
of the judgment, compilation of judgment.
Compilation.
Yeah. Reasons for enactment of the NP Act.
Yes.
My lord has got it.
Yes. This Transcode Union of India.
Yes, Lord.
Yes.
Married, Lordship. The NPA Act 2002 is enacted to regulate securitization and reconstructions of financial assets and security of enforcement of security interest for matters connected with therewith. The NPA Act.
NPA here is this
Surface Act.
Surface Act.
The NPA Act is renamed as Surface Act. Enables the banks and financial institutions to realize long-term assets, manage problems, liquidity, assets liability mismatch, and to improve the recovery debts by exercising powers to take possession of the securities, sell them, and thereby to reduce the non-performing assets by adopting measures for recovery and reconstruction. The NPA further provides for setting up of assets reconstruction companies which are empowered to take possession of secured assets of the borrower, including right to transfer by way of lease, assignment, or sale. The said act also empowers the assets reconstruction company to take over the management of the business. The constitutional validity of the said act has been upheld by in so and so after the judgment of this so and so amending section 30, Act of 30. 2004 was inserted, but the Act of 30 in section 19(1) of the DRT Act was recasted simultaneously with section 13 of the NPA Act. These amendments were made in order to enable the bank and financial institution to withdraw with the permission of the DRT OS and to made it, and therefore thereafter to take action in the NPA. In the judgment of so and so, this court observed that in cases where the secured creditor has taken action under section so and so, it will be open to the borrower to file application under section 17 of the NPA Act. Now, why I'm drawing your lordship's attention to the very purpose, because before I take up your lordships to the judgment and other purpose. Now, lordship, when the account is classified as an NP, it is not classified as an NP. It is after classified as an NPA that the bank resorts to measures under the Surface Act. This is the first and foremost thing. Now, under the Surface Act, every act of the bank is time bound.
Every act of the bank is?
Bank is, because the measures to be taken by the bank is time bound, is in the Surface Act. Even the notice under section 13(2), the period of notice has to be 60 days. After 60 days, we can take steps under section 13(4). That is symbolic position. Even the sale notice is also there. Prior notice of 30 days has to be given. And recently after Lordship is well aware of the Bafna case, that we have to issue redemption notice also of 30 days prior to the sale notice. That is after the celebrated judgment of the Bafna case. Now, why I'm drawing your Lordship's attention? Because if a person is aggrieved by the measures taken under section 13(4) of the secured creditor, being the bank, he has the right to approach to the debts recovery tribunal under section 17. And the limitation provided is 45 days.
Yeah.
Now, Lordship, under section 34 of the SURFACI Act, the jurisdiction of the civil court is totally barred. Now, if a person intends to file a civil suit also, he cannot. Previously, before coming, he could have gone. Now, the celebrated judgment of the Mardia Chemicals case says it is as good as a civil suit. I'm coming, it is as good as civil because it is section 17 application is the application filed by the borrower is the court of the first instance. It is akin to a civil suit. Now, if it is an akin to the civil suit, Lordship, whether limitation act will apply, because it is a, supposing if I am filing a title suit, Lordship, the limitation for title suit or money suit is such and such. Can I file an application for condemnation of delay? Certainly not.
Can't.
No, this is Lordships in the findings. I'm taking your Lordships to page of my judgment. Firstly, the Mardia Chemicals case. My Lord is well aware, even then, I like to take your Lordships. Page, para 59, page 42. 42.
Of the compilation?
Of the compilation. My Lord has got it. This is in respect of section 17 of the SURFACI Act.
42.
My Lord has got it. Page 42 of the compilation.
Fine.
Paragraph 59. May I read?
Yeah.
We may observe that the proceedings under section 17 of the Act which the Honorable Apex Court is referring to is the Act under SURFACI Act. In fact, are not appellate proceedings. If it is not appellate proceedings, certainly it is an original proceedings. It seems to a misdemeanor. It is in fact initial action which is brought before a forum as prescribed under the Act, raising grievance against action or measures taken by one parties the contract. It is the stage of initial proceedings like filing a civil suit of a civil court. As a matter of fact, proceedings under section 17 of the Act are in lieu of a civil suit. Very specific, Your Lordship. Which remedy is ordinarily available, but for the bar under section 34 of the present case. So, when there is a bar under section 34 of this Act, a person is going to this debts recovery tribunal under section 17. It is a suit of a civil nature, a suit of initial state. So, if it is original jurisdiction.
We understand your argument.
Now, Lordship will take.
Now we understand your argument, please. Now come to this section 17.
I'll be coming, Lordship. There is an interpretation. Section 17 and 24, I'll be coming, Lordship. Section 24 and section 17 and 24.
24 of what?
Of DRT Act.
DRT Act.
Yes.
But section 17(7).
Yes.
Says that it doesn't say that the proceedings under section this section this 17 would govern by the CPC. Says that this DRT Act would be applicable.
Yes, Lordship. That is why I'm submitting with your Lordship.
that
That is why I'm submitting before Lordship. Section, save is otherwise provided, the debts recovery tribunal shall, as far as may, dispose the application in accordance to the provisions of the Recovery of Debts and Financial Institutions Act 1993. I'm not denying to that. Now, if the debts recovery tribunal disposes the application under section 19 application before the debts recovery tribunal is an original jurisdiction of the debts recovery tribunal.
in
It is
accordance with the provisions of so and so.
so and so. Similarly, Lordship, in accordance, so as far as Surface Act is concerned, Surface Act says that since the application is filed before the debts recovery tribunal, Surface Act does not say it should be filed in a tribunal of Surface. Surface Act says that the application under section 17 has to be filed before the debts recovery tribunal. And that is why the procedures of the debts recovery tribunal will follow. Now, Lordship, taking for a moment the debts recovery tribunal, Recovery of Debts and Bankruptcy Act.
Yes.
I'll take your Lordship. Section 22. My lord has got
Yes.
it. Procedures and powers of the tribunal and appellate tribunal. Tribunal, my lord, is the debts recovery tribunal, and the appellate tribunal is the DRAT. The tribunal and the appellate tribunal shall not be bound by the procedure laid down by the civil procedure, but shall be guided by the principles of natural justice, and shall be subject to other conditions and of this act and the rules of the tribunal and the appellate tribunal. The tribunal and the appellate tribunal shall have for the purpose of discharging their functions of the act are vested in a civil court under the Civil Procedure Code, while trying, summoning evidence, and enforcing evidence, attendance of person in requiring discovery of inspection, receiving evidence and affidavit, issuing commissions of examination of witnesses, reviewing the decisions, dismissing application for default, deciding it ex parte, setting aside order of dismissal of any application for default or any order passed ex parte. Any other matters which may be prescribed. Any proceeding before the tribunal or appellate tribunal shall be deemed to a judicial proceeding within the meaning of section so and so of the Indian Penal Code, and the tribunal or the appellate tribunal shall be deemed to be a civil court for the purpose of so and so. So, Lordship, I'll take your Lordship to para 62 of the judgment of the Madhya for a moment. Read it.
Yeah.
As indicated earlier, the position of an appeal under section 17 is like that of a suit in a court of the first instance under the Code of Civil Procedure. No doubt, in a suit, it is permissible to, in a given facts and circumstances under these provisions, of the law to attach the property before a decree and to appoint a receiver. Now, Lordship, I'll take your Lordship straight to which is the finding of the Honorable Apex Court in paragraph 76, page 50. Paragraph 76, page 50. My lord has got it.
Yes.
In regard to the submissions made by the parties as indicated in the proceedings paragraphs, we would like to make it clear that issue of notice to the debtor by the creditor does not attack an application of principles by the natural justice, it will be open to tell the debtor that he owes to repay. No hearing can be demanded from the creditor at this stage. So far as the provisions of appeal is concerned, we have already discussed in the earlier part of the judgment that the proceedings under section 17 of the act have been wrongly being described as appeal before the debt recovery tribunal. In fact, it is in fact a forum where proceedings are originally initiated in very specific term, Your Lordship, initiated in case of any grievance under section 7.
We can't limit the application of these other acts in view of these observations only. They have simply said that though it says that appellate tribunal, but actually it's are the original proceedings like a civil suit.
Lordship.
Not exactly this civil suit, like a civil suit. Here, but we can't ignore the other provisions of this section 17. Section 17(7) says that the procedure as applicable as provided in the DRT Act would apply. DRT Act says that Limitation Act has application. Then why should not the drawing the same
Limitation,
analogy?
I'm
drawing the
coming to
analogy
Lordship.
from Baleshwar Dayal.
Baleshwar Dayal, Lordship, is pertaining to section 18 of the act.
That's why.
Section
drawing
18
that
says of the
analogy,
appeal,
drawing that
not,
analogy.
not section 17.
He understands that. Yeah.
Section 18. Baleshwar Dayal says of the section 18. No, I'm that good. May I read section? Lordship.
The proceeding under for an of the will be considered by the sector 20. We are still considered.
No, Lordship. 17. 17, not 19.
17 of what?
Surface Act.
No. An application of the Surface Act will be considered by the tribunal by exercising what provision? It will exercise the provision under the DRT Act. And the provision under DRT Act will be 19.
No, provision under the DRT Act. So, Lordship will see section 19. Section 19 relates to filing of original application. So far,
Dear,
yes.
This is also an original application.
Lordship.
So if it is an original application, it is same.
Yes.
The power that the tribunal could exercise, it is the same. And it could exercise when the bank comes before it for recovery. Right? Files an OA for recovery. And the application file for benefit under section 17 would be sent.
Now, Lordship, just Lordship, for a moment, section 24 of the limitation of the DRT Act. That it makes clear the provision of Limitation Act 1963 shall then very much clear as far as may be. As far as may be shall apply to an application made in it. As the word as far as may be is as far as it is necessary, we may interpret it.
It is necessary,
or
then
as
they
far
will
as
apply, otherwise they
applicable.
will not apply. As
No, now let us take the entire DRT Act. Now, this comes in question of appeal before the DRT or DRT, not in original jurisdiction. As Because in original jurisdiction, my lord, may I submit? If it is in original jurisdiction, taking for lordships, then in section 19 also it comes, I file a civil suit, I file an original application. No, lordship.
There is two different tribes. One is the tribunal, and the one is the appellate.
Yes.
Section 24 applies to the tribunal.
No, appellate tribunal.
No,
Appellate tribunal.
only tribunal.
Only you see the.
Only tribunal.
That has been part stated in the subsequent judgment, lordship. I'm coming to that. I'm coming to that. I'm coming to that, one by one. My lord will come to page of the Honorable Apex Code itself. Yes. In page 101. In page 101. Page 101. Lordship of the my compilation of judgment. AIR 101. AIR 2017 Supreme Court, page 5013. There is four. And reading paragraph 12 first. Page 104.
None.
Not international assets, lordship.
Yeah.
An application is defined under section 2B of the RDB Act. My lord has got it. Application, my lord was just referring upon.
Yes.
An application marriage was page, paragraph 12, page 104.
Yes.
An application is defined under section 2B of the RDB Act as one made under section 19 of the Act. The latter provisions of chapter 4 deals with institution of original recovery proceedings before the tribunal. An appeal against the order of the tribunal under section 20 before the appellate tribunal within 45 days, which may be condoned for sufficient reasons, and under provision to section 20 within bracket 3 of the Act, the tribunal issues a recovery certificate under section 19 within bracket 22 of the recovery to the recovery officer, who then proceeds under chapter 5 for recovery of certificate of the amount mentioned in the prescribed. A person aggrieved by the order of the recovery officer can prefer an appeal before the before the tribunal under Rule 4 by an application prescribed in Rule Form 3, Rule 2 to C defines an application to include memo of appeal under Section 31. The appeal to be preferred before the tribunal as distinct from the appellate tribunal within 30 days. Section 24 of the RDB Act therefore manifestly makes the provisions of the limitation applicable to only to such original application made under Section 19. The definition of an application under Section 2C cannot be extended in conjunction to Section so and so, extending the meaning beyond the provides of the Act and of the RDB Act. Next, I'll take your lordship to page 14. That is clear now. Paragraph 14. RDB Act is a special law. The proceedings are before statutory tribunal. The scheme of the Act manifestly provides legislature has provided application of limitation original proceedings before the tribunal in Section 19. The appellate tribunal has been conferred to condone the delay beyond 45 days under Section so and so. The proceedings before the recovery officer are not before the tribunal. Section 24 is limited in its application before the proceedings before the tribunal originating under Section 19. The exclusion of the extension of the time by the tribunal in preferring appeal under Section 30 makes it manifest that the legislature intent was expressed. The application of Section 5 of the Act by resort to Section 29(2) therefore does not arise. Now, lordship, another judgment, lordship.
Now, this debtor being agreed with any of the measures under Section 13(4) has to apply under Section 17 before the debt recovery tribunal. What is this debt recovery tribunal?
The Debts Recovery Tribunal, lordship, is established under the Recovery of Debts and Bankruptcy Act 1993.
1993.
Lordship.
It says the debt recovery tribunal means the tribunal established under subsection 1 of Section 3 of recovery of debt, this Act of 1993.
Lordship.
And Section 7 says, save as other provision in this, that recovery tribunal as far as may be dispose of the application under Section 17
Lordship.
in accordance with the provisions of Recovery so Act of 1993.
Lordship.
It says the Debt Recovery Tribunal, Section 24 says that this limitation act is applicable. Then how you can exclude this, sir?
Lordship, just for a moment, may I just...
The same tribunal, the tribunal, Debt Recovery Tribunal means the tribunal established under section, under the provisions of Act of 1993, the DRT Act.
Section 24, the limitation...
Section 7
what
says
I mean to...
procedure is to be governed by the Act of 1993.
Limitation Act applies does not apply to the original juris. It applies to the appellate, lordship.
No, sir. It's applied to this. No, if we go to the DRT Act, Section 19 is original application. Section 19 speaks about the this recovery proceedings. These are the original proceedings. Application.
May Lord,
Section 19, read.
Section 19, lordship.
Application to the tribunal.
Yes.
These are the original proceedings.
Lordship. Application to the tribunal, or so far the original proceedings are concerned, lordship. So for the original, the limitation is specific in the Limitation Act itself. The limitation is specific in the Limitation Act itself. When the bank files a suit, it has to go within the period of limitation, that is 3 years.
Fine.
The Limitation Act is specific on this point, that beyond the limitation, the bank cannot file a suit for recovery. Now, lordship, I'll take your lordship to page 148. page 148.
Yes,
That is, that judgment specifies lordship, my lord's query also to some
148.
page 148. This is by the Honorable Calcutta High Court.
Yeah.
Therefore, a pure question of law arises for determination of appeal whether an application for condonation of delay in preferring an application under section 17(1) of the SURFACE Act beyond the period of 45 days can be allowed by exercising power under section 5 of the Limitation Act. In order to appreciate the aforesaid question, it will be profitable to refer to section 17, 35, 36, and 37 of the SURFACE Act and sections 24 of the Recovery of Debts and Financial Institutions Act and also section 29 of the Limitation Act, which are quoted below. All these sections have been taken into consideration. Now, what the Honorable Court has come to conclusion, may I take your lordship to page 149.
149.
Next page.
Yeah.
Limitation. No secured credit under serial number 36, no secured creditor shall be entitled to take or any measures under subsection 4 of section 13 unless his claim in the financial assets is made within the period of limitation under the Limitation Act 1963. Application of other laws barred. The provisions of this act or the rules made thereunder shall be in addition to and not in derogation of the Companies Act, Securities Act, and the so and so Act. Limitation, now say the provisions of limitation 1963 shall, as far as may apply to an application made in this tribunal. Now, next page is very important, yeah, lordship, page 150. Nothing in this act shall affect section 25 of the Contract Act. When any special law or local law is prescribed for any suit, appeal, or application, a period of limitation from the period by the schedule of section 3 shall apply, and if such period where the period for the schedule for the purpose of determining any period of limitation of any suit, appeal by special law, the provisions contained in section 24 to 24 inclusive shall apply only insofar as to the extent to which are not expressly excluded by the special law. Now, thereafter, the Honorable Court has held. I'm skipping over to the third paragraph, lordship. Therefore, the only question arises for the determination as to whether section 5 of the Limitation Act for condonation of delay applies in proceedings under section 17. In view of section 7 of the 17, in view of section 7 of section 17 of the SURFACE Act, and the Debts Recovery Tribunal shall, as far as may, dispose the application in accordance to the provisions of the Recovery of Debts and Financial Institutions Act, which my lord has just pointed out. It further appears that according to section 24 of the Recovery of Debts and Financial Institutions Act, the provisions of Limitation Act as far as may, apply to an application to the tribunal. The conjoint effect of section 17(7) of the SURFACE Act and section 24 of the Recovery of Debts and Financial Institutions Act is that the proceedings under section 17(1) of the SURFACE Act, which is entertained by the Debts Recovery Tribunal, the provisions of the Limitation Act shall, as far as may, apply. Although section 17 of the SURFACE Act has been described in the said act as one conferring a right to appeal, as held by the Honorable Apex Court in so-and-so and versus so-and-so, and in the case of so-and-so and so-and-so, and in so-and-so, the proceedings under section 17, in fact, are not appellate. It seems to me say, according to the Supreme Court, it is in fact initial action which is brought in the forum of the act, forum as prescribed under the act, raising grievance against the action of the measures taken by the party. Therefore, according to the Supreme Court, it is a stage of initial proceedings like filing of a civil court. It is further pointed out by the Supreme Court that as a matter of fact, proceedings under Section 17 are in lieu of the civil code, which remedies only available as remedies but for a bar created under Section 17. After the decision of the Honorable Supreme Court in Mardia Chemicals, the language of Section 17 was amended, and instead of appeal, the word application was introduced in the section, although marginal note was not changed. In the subsequent decision of the Supreme Court in Transcourt Supra, the Supreme Court has, after taking into consideration the amended provisions of Section 17, pointed out the marginal note of Section 17(1). The Surface Act could not control the text, text content of Section 17(1), and following the earlier decision of the Mardia Chemicals, reiterated that the section exercises original direction. The following observations of the apex courts are quoted. Now, after taking into consideration this one, Lordship, I am coming to the last paragraph. We therefore hold the proceedings under Section 17 that under the provisions, under the Section 17(1) of the Surface Act, the provisions of Limitation Act applies in general as far as may be. Yet, Section 5 of the Limitation Act in particular, however, has no application in view of the fact that the proceeding is original in nature, like a suit, and Section 5 has no application to the suit. In following this judgment, Lordship, thereafter in page 158, the intention of the legislature also been stated in page 158.
Yes.
Now, Lordship, page 158.
Yeah.
I'm skipping over to paragraph 6. Page 158, paragraph 6.
This is
Same judgment.
same judge.
Yes. May I read, Lordship?
Yes.
Our aforesaid interpretation of Section 17(1) gets the support from the intention of the legislature as reflected in the section itself, wherein Section 5, subsection 5 thereof, a time limit of 60 days has been given for disposal of such application. And according to subsection 6, the application, if not disposed of by the tribunal within 4 months, and any party to the application may make an application in such forum as may be prescribed to the appellate for directing the Debts Recovery Tribunal for expeditious disposal of the application pending before the Debts Recovery Tribunal. Now, what I'm drawing your Lordships, is the time limit, even for disposal of the application under section 17 is 60 days. And the maximum period is 4 months. So if a limitation application is made applicable, then in 4 months,
4 months from the date of filing of application,
yes, from the date of filing,
not from date of filing. So whenever the application is filed,
The-
either by delay, the tribunal proceeds to condone the delay.
no,
The 4 months start from there.
no, no, Lordship. From the date of the, therefore, they are being specific. No, যখন থেকে fight.
আমি দেখেছি কোন সার্ভিসে অ্যাপ্লিকেশন তার মধ্যে লিখতে বলার কথা
Date of such application, the limitation period of 4 months start from the date of such application.
No.
It is filed by delay after condoning the delay in the appropriate case, then only it can be proceeded.
Now, Lordship, next paragraph. Therefore, there being specific time limit of 45 days for invoking original jurisdiction under section 17, which has been found to be the essence, in essence, a suit and a further tentative limit of 60 days for disposal of the application, giving a right to the party to complain before the appellate forum for compliance of such provisions alleging violation thereof, if not completed within 4 months, it was never the intention of the legislature to apply section 5 of the Limitation Act to such original proceedings by giving power to entertain an application under section 17(1) of the Surface Act by merely showing sufficient cause for delay without putting any restriction upon the tribunal. We therefore hold that the time of 45 days providing in section 17 of the Surface Act, which is original in nature, cannot be extended by taking section 5 of the Limitation Act. Next, Lordship, is the judgment of the Orissa High Court.
Yes.
In the Orissa High Court also, Lordship, in page 164, marriage, paragraph 26, Orissa High Court. At this stage, it is necessary to refer to the provision of section 17(1) and 17(7) and section 24 of the RDB Act, all taken together. The said provisions of section 17(1) and 17(7) of the Surface Act are read. I am not reading, Lordship, because my Lord knows it. Next, I will take Lordship to page 165. It was explained by the Honorable Apex Court in the above decisions of International Assets Company versus Official Liquidator so-and-so, that section 5 of the Limitation Act applies only to original jurisdiction under section 19 and not to appeal under section 30. The RDB Act is a special law. The proceedings before the statutory tribunal. The scheme manifestly provides that the legislature has provided application to the Limitation Act to original proceedings before the tribunal in section 19 only. The appellate tribunal has been conferred with the power to condone the delay beyond 45 days and the section 20 of the proceedings before the recovery officer are not before the tribunal. Section 24 is limited in its application before the tribunal originating under section 19 only. The exclusion of any provision for extension of the time by the tribunal in preferring appeal under section 30 makes it manifest that the legislature intends to exclude the time. Now Lordship, paragraph 29. Consequently, the Supreme Court has distinguished the decisions in Air Venugopal, which was held that the appeal filed under section 31 beyond the 30 days was condonable under section 30, read with section 24. The said decision therefore impliedly overruled. The resultant legal position is the DRT has no power to condone the delay in filing appeal before it, either under section 17(1), or under section 17(1) of the SURFACE Act or under section 31 of the RDB Act. As can be seen, section 17(7) of the SURFACE Act expressly states the DRT shall dispose the application under section 17(1) in accordance with the provisions of the RDB Act. Neither section 17(1) nor section 31 of the RDB Act permits DRT to condone the delay in filing the appeal beyond the prescribed period. In view of this matter, the present case, DRT was in error in condoning the delay and allowing the opposite party to file it. So the delay was not condoned. In similar line, Lordship, though my lord is not bound by this judgment, still it is the judgment of the Honorable Debts Recovery Appellate Tribunal. If my lord may just peruse it, it is page 176. It is in Debts Recovery Appellate Tribunal, Calcutta, by my Lord Justice Anil Kumar Srivastava. No, it is following the judgment of the Honorable Apex Court.
Apex Court with judgment.
I'm coming to the Apex Court judgment also, Lordship. On this point, the latest judgment of the Apex Court is at page 106. The Apex Court judgment after the Mardia Chemicals. Bank of Baroda versus Procedural Tulsiram. Page 108. The relevant portion in paragraph 12, page 108.
It is not a mere observations.
The reasons for providing the a time limit of 45 days in filing application under section 17 can be easily inferred from the purpose and object of the enactment. Then the transcourt judgment has been referred to. In the transcourt judgment, it is specific. Had the Honorable Apex Court been deferred with the judgment of transcourt or Mardia Chemicals, it would have been reflected here. The Honorable Apex Court rather relied upon the judgment and says why it is specific. The Honorable Apex Court did not say that the delay needs to be condoned. It is specifically stated why the object of the enactment for providing limitation of 45 days. Now, relying on this judgment, Lordship, the Honorable DRAT relying on the judgment of the Honorable Apex Court in page 176. Recent, 2023. It is pending before the Apex Court of the Canada High Court.
Yes.
Relying on this judgment, Lordship, the Honorable DRAT Calcutta have relying on the judgment of the Honorable Apex Court in page 176, mail it.
Yeah.
As far as the question of condonation of delay in filing application under section 17 of the Act is concerned, it was held by the Honorable Apex Court in so-and-so versus so-and-so, decided on so-and-so. The reasons for providing the time limit of 45 days for an application under section 17 of the Act can be inferred from the purpose and object of the enactment of the Surface Act is the quick enforcement of the security. Hence, it is clear that the period of limitation of 45 days in filing the application is mandatory, which cannot be extended or delay in filing the application on section 17 cannot be condoned. Next, another judgment of the Honorable in so-and-so for the so-and-so, decided in so-and-so, the division bench of the Odisha High Court, Cuttack, reliance placed on the judgment of the three judge of the so-and-so Supreme Court, wherein is held that this by the Honorable Apex Court. The section original and not in this which I just referred, Lordship. Now, relying on this judgment, my lord has my learned friend has referred to Baleshwar Dayal's judgment. In Baleshwar Dayal Jaiswal's judgment, Lordship, the Honorable Apex Court has referred to section 18(1).
Yes.
Lordship, in the case of Hindon versus State of Uttar Pradesh.
Which one?
Hindon Forge Private Limited versus State of Uttar Pradesh.
Yeah.
In this case also, Lordship, the Honorable Apex Court relied on the judgment of the Apex Court in Mardia Chemicals case.
109.
It starts at page 109 and the relevant portion it is page 131. And 133, where again it has been reiterated that section 17 application is that of a civil suit. (131) Lordship, paragraph 8.
Yes.
This court in Mardia Chemicals Supra, after referring in detail.
So this is a mere repetition of Mardia Chemical which you have read already.
Yes. Yeah. This judgment has again been referred to and relied upon.
Again referred to and?
In Hindon Forge.
Yeah, Mardia Chemical.
In Mardia Chemicals case. That's it has been again been held that
it's a civil, akin to the civil suit.
Yes, section 17 application is a civil suit. Now, what is my submission, Lordship? If it is a civil suit, I'm summing up my submission. If it is a civil suit, it is a suit of an original nature.
Yeah,
If it is suits of original nature, Section 5 of the Limitation Act has no application to it. This is my humble submission. Of course, your lordship will decide on this point, whether it's in a suit of a civil nature under of an original jurisdiction,
like
whether
a
section
suit, not a suit. Like
No,
a suit, not a suit.
as held in Murder Chemicals case, lordship,
Like
as
a-
held in Murder Chemicals case,
As held in Murder Chemical, it's like a suit, not
it
a
is
suit.
not it is like a suit of civil nature. I'm just like a suit of a civil nature.
We'll consider it.
Yes, lordship.
Well,
I leave it to your lordship.
In Madhya Chemicals, he is referring, just point out one single small point. Nowhere it is stated a limitation and will not apply. Nowhere it is stated. And all the applications, why the word application has been used in surface the application. So in case of whether in case of civil suit, whether what application has been used cannot be used. This is their definition. And then while learned friend relied on one judgment of DRT based on FSCO judgment. That what I have remembered, I don't know, I don't have a copy, but still I remember that judgment is on the, they have just made an observation of FSCO, not on merit.
The judgment itself cleared. Obliged, lordship.
May I please also, lordship, the next two items, can it be taken up on 19th or 21st? A bit urgency on our part.
Hearing day.
Yes, my lord, Tuesday or Thursday?
Lordship, any day after 19th, your lordship.
Any day after 19.
26th, maybe. 20.
My lord, much obliged.